Hi, can you hear me? Justice, can you hear me? And are you able
The,
to talk?
the, yes, I
Okay,
can. The
hello?
host muted everyone.
No, on
Hello?
our side, with nonsense are here, and
Hello?
everything is just fine.
Uh,
Prof, can I hear you? Can you hear me? Can you talk?
Hello?
Okay, now it's okay. I don't know what had happened. You can go.
No, but
You
I think
can.
you need to know what is happening. It might repeat Mavedzenge. I get messages saying I've been muted by the host. And indeed, I have shared with some of your people. I hope they gave you.
Okay. So I think when Nonsansa was switching to a different network, something would have happened. But we are now in the same room, in the same space, on the same network. It should work.
Yeah. I hope it was not a case of gremlin in the morning.
It's not sabotage.
They usually appear at night. But thank you. I have lost a lot of time. I hope you will be considerate if I somehow lose the 10 minutes that you have afforded me. But I was making a point, a preliminary point, that by their very nature, constitutional issues are not rocket science. They are everyone's issue. And that's why in our country, which perhaps because people are too much into textbooks, they think that constitutional issues are an exclusive preserve for lawyers. And yet, in fact, these issues are important precisely because they are everyone's issues in the literal sense. That's why a good constitution or a good constitution moment, such as this one, is the one that has something for everyone. And when that is clear, that's when the lawyers come to draft. But drafting what is not coming from their heads, but is coming from the aspirations of the people, in this case, not only through such conversations, which started on Monday, or more technically on Tuesday, the counting of the 90 days. Otherwise, I would like to thank you for this opportunity. I want to start by pointing out that a presentation to a discussion of this nature must, in my view, begin by stating what the essential and critical issue is, which happily in this case, it is common cause that it is about the Constitution of Zimbabwe Amendment number 3 bill approved by Cabinet last week and gazetted by Parliament this week. As one among many others who have been intimately involved in constitutional reviews over the last 26 years, notably during the people-driven exercise that produced the 2000 draft constitution prepared by the Constitutional Commission and the compromise constitution between ZANU-PF and the two MDC formations that produced the current constitution. It is my considered view that the Constitution of Zimbabwe Amendment number 3 bill represents a profound recalibration of our country's democratic or political architecture. So, the foundational question of my intervention this morning is based on this question that I pose. What is the motivation or mischief that the bill is addressing? It's not coming just dropping into our midst or body politic like manna from heaven. It is a response to a particular situation or mischief which motivates it. And to have a meaningful debate, I think it is important to unpack or understand that mischief. In my view, the mischief being addressed by this bill is twofold. This is, I emphasize, my view. One is that there's this perpetual conflict mode in our country arising from its system of electing the president, which was introduced in 1987. We should bear in mind as we debate this, that when this system was introduced at that time, it was in anticipation of the establishment of a one-party state. The 1987 amendment was enacted with explicitly the intentions of establishing a one-party state in our country. And then things happened. And by 2000, government set up a constitutional commission to review the entire constitutional edifice of the country. But in particular, consequences that had arisen as a direct result of the introduction of the executive presidency in 1987. The 2000 constitution, draft constitution that is, sought to address this issue under a hybrid compromise that sought to bring back the office of the prime minister, drawn from the party in parliament commanding the majority as the head of government, while retaining the president as the head of state, but with reduced executive powers. Unlike the 2000 draft constitution, at least from the point of government, since that process was a government process, the 2013 constitution did not even attempt to address the issues related or rooted in the 1987 amendment. Instead, it retained the presidency, the executive presidency, created in 1987 in anticipation of a one-party state, but this time retaining it under a constitutional framework for a multi-party democracy enshrined in Section 3.2a of our Constitution, and which framework has a running thread throughout the rest of the Constitution. The Constitution enacted in 2013 presupposes the existence of a multi-party democracy. But the executive presidents, which was inherited without even a single amendment in 2013, was, and this is not, this is an open secret, but it is an objective structural question. It was enacted anticipating that by 1990 or after the 1990 general election, there would be a one-party state. But it didn't happen. The fact that this was retained in 2013 by a constitution whose framework anticipates a multi-party democracy naturally led to a self-evident structural breakdown, which has spoken for itself since 1990, exemplified by the scourge of disputed presidential elections and the toxicity associated with it. That's the first mischief that the amendment or the bill is addressing. The second mischief is that over the years, but this is a colonial or pre-colonial problem of all countries that were under colonialism, such as Zimbabwe, which adopted a shorter 4- or 5-year term of office for the elective institutions, namely the executive and the legislature. The adoption of this short term of office provisions or structures or election cycles has been problematic in that the period is too short and tends to perpetuate permanent election modes, with the next election starting immediately after the last, breeding populism over service delivery, exacerbating societal divisions, ethnic divisions, and leading to bureaucratic inefficiency. Data from at least the 16 African countries in the Commonwealth shows without doubt that shorter terms of office adopted in post-colonial constitutions ostensibly to promote democracy and accountability often have tended to incentivize divisive rhetoric, divisive politics, ethnic mobilization, and critically, the neglect of long-term infrastructural development within fragile contexts, which have weak institutions and which perpetuate instability, such that the traditional enemies or grievances of the people that fueled the nationalist struggle, hunger, poverty, disease, ignorance, have not been addressed. They are difficult, if not impossible, to address within shorter election cycles. Therefore, in my view, by amending sections 92, 95, subsection 2B, 143, subsection 1, and 158, subsection 1 of the Constitution, the bill addresses these two mischiefs. And it does so not by altering the structure of government or its fundamental institutions, but principally or in the main, by transforming the system of electing the president and the period or the duration of the national election cycle, which affects only two branches of government. Those people who talk about power, whether it's executive power in Section 88 derived from the people, or the legislative authority derived from the people, and saying, therefore, you must have direct elections, must confront the reality that judicial power is also derived from the people, but the people do not directly elect the judges. But in any event, the point is that this reform package, constitutional reform package, whose core amendments are those that I've outlined, directly tackles these two situations that I outlined just a little while ago. In the circumstances, the reforms in the bill are neither cosmetic nor partisan. They are historic, strategic, forward-looking, and deeply patriotic. In particular, the reforms in the bill seek to strengthen Zimbabwe's hybrid electoral system, which has developed to be one of the best, the hybrid election system that is, in order to align it first and foremost with Zimbabwe's constitutional realities going back to at least 1987, as I pointed out, and to also, in the second instance, align it with proven best practices in the SADC region and in the Commonwealth, which Zimbabwe seeks to rejoin. All told, the reforms position Zimbabwe for institutional maturity and enduring stability. And in this regard, quickly, but hopefully without losing much of the content, I would like to highlight 5 or so underlying principles that are necessary to understand if we appreciate what the foundational question is in terms of the mischief being addressed and what the core amendments seek to do about that foundational question? So quickly, 5 things. Firstly, and at the heart of the gazetted amendments, lies the foundational constitutional principle under Section 117, subsection 2A of the Constitution. The principle is that the current 10th Parliament possesses unassailable authority to amend the Constitution in accordance with Section 328. It is bound neither by the 7th Parliament that gave birth to this Constitution, nor by the 8th and 9th Parliaments that enacted later amendments to it in 2017 and 2021, respectively. This legislative independence of the 10th Parliament is not a technicality. It is the living expression of the democratic doctrine that one legislature cannot bind its successors. It is called the anti-entrenchment rule. No parliament may forever shackle those parliaments which come after it. Each new parliament is sovereign and retains the unfettered right to repeal, amend, or replace the laws of its predecessors. To deny the 10th Parliament this principle would, in my considered view, be a dangerous surrender to the tyranny of temporal majorities, allowing yesterday's choices to imprison today's realities or will. Permanent entrenchment of laws freezes progress and suffocates hope. The 10th Parliament, therefore, stands not merely authorized, but solemnly duty-bound to shape Zimbabwe's constitutional destiny with courage, clarity, and unyielding authoritative legitimacy. That's where legitimacy comes from, not from the whims and caprices of players in the political process. Secondly, the constitutional prescribed process for amending the Constitution is enshrined in Section 328. This section establishes a rigorous, multi-layered procedure designed to prevent hasty or self-serving alterations or amendments of the Constitution, while empowering Parliament to refine governance in response to evolving national situations and aspirations. This is why any constitutional bill must be published with precise terms, allowing at least 90 days for public consultation in terms of Section 328 for consultation and scrutiny to enable the broad societal input. The bill must then secure the affirmative votes of at least 2/3 of the membership of both the National Assembly and the Senate at its final reading, a threshold that demands cross-partisan consensus. This way, the amendment process honors the foundational principle that the supreme law of the land derives its authority from the will of the people expressed through their parliament. This is in the Constitution. Thirdly, and critically, Section 328, subsection 6, reserves the ultimate democratic veto, namely the referendum or national referendum, but it does so only for the most sacred and entrenched elements of the constitutional order, namely any constitution bill seeking to amend provisions within Chapter 4, the Declaration of Rights, or Chapter 16 concerning agricultural land. Section 328, subsection 9, extends this similar protection to Section 328 itself, deeming it an integral part of the Declaration of Rights in Chapter 4. It is only and only in these 3 exceptional cases where a constitution bill, having secured 2/3 approval in Parliament, must be submitted to a national referendum within 3 months, in which approval by a majority of participating voters is indispensable. All told, the referendum in constitution making in Zimbabwe is not a matter of the wills and caprices of people who demand it or use it as a political weapon. It is strictly a matter of law, not conjecture or an expression of the desires and wishes of political players who invoke it usually for conflict mongering. Otherwise, for all other provisions that are in the Constitution, outside Chapter 4, Chapter 16, and outside Section 328, such as those that are affected or specifically covered in this bill, the prescribed process demands nothing more than the parliamentary threshold of 2/3 majority without a referendum. This is the constitutional position as it is. The 2013 Constitution, in its wisdom, mandates referendums only for amendments that I outlined. Any demand that referendums extend to other provisions is, and I emphasize this, illegal and unconstitutional. That we can pronounce. Some people pronounce amendments as illegal. They are not, because they seek to change the legal position. But how those amendments are made is a matter of law as prescribed under 328. Fourthly, there are claims that amending a term limit provision necessarily triggers a referendum. This is false in my respectful opinion. Recall that the Constitution mandates referendums only for amendments to Chapters 4 and 16 and Section 328. There is not even one term limit provision that falls under these parts of the Constitution. And this is not to say anything about the bill, but to say something about term limit provisions. There are 15 term limit provisions in the Constitution, and none of them is touched by this bill. So, and in fact, conveniently, these were circulated or shared yesterday by the Attorney General. And there is, however, an exception under Section 3287, where or if an incumbent is to benefit from an amendment to a term limit provision, not another provision, but a term limit provision, then Section 3287 is triggered and a referendum might be required if the intention is to benefit an incumbent who holds an office which is subject to which has term limit provisions as defined by the Constitution. But to be clear, Section 328, subsection 7, comes into play or imposes a referendum only if an amendment is to a term limit provision. And we should underline that, to a term limit provision and not to any other provision. And if the amendment extends an incumbent tenure for someone who held the office before its enactment. Section 328, subsection 7, provides that notwithstanding any other provision of this section, an amendment to a term limit provision, the effect of which is to extend the length of time that a person may hold or occupy any public office, does not apply in relation to any person who held or occupied that office or an equivalent office at any time before the amendment. I emphasize, colleagues, this applies to an amendment to a term limit provision. It's not only term limit provisions that talk about time. There are many other provisions in the Constitution which are not term limit provisions, but which have something to do with time. An example being Section 95, subsection 2B, and Section 143, subsection 1, or even Section 158, subsection 1. But we have to be clear. The operative phrase in Section 3287 is that the affected amendments must be a term limit provision, not any other. And subsection 1 of section 328 provides that a term limit provision means a provision of this constitution which limits, the provision must limit, which limits the length of time that a person may hold or occupy office. If the provision talks about time, but it does not limit, does not put a cap on the time, then that provision is not a term limit provision. For a clause or section of the Constitution to qualify as a term limit provision, it must expressly and unambiguously put a limit or a cap on the time that a person may hold or occupy the office. If there is no limit or cap in that provision being looked at, then that clause or section is not a term limit provision as contemplated in section 3281. Using dictionary definitions of the words term and period, the Constitutional Court in the landmark case of Max Mupungu versus Minister of Justice, Legal and Parliamentary Affairs and 6 others held that, I quote, a term is defined as a fixed or limited period for which something, for example, office, imprisonment, or investment lasts or is intended to last, while a period is defined to mean a particular length or portion of time. In other words, in the language of section 143, subsection 1, a duration of time of parliament is a period. In light of these definitions, a term is a period. This is in the Mupungu judgment. In the light of these definitions, a term is a period of time which is ordinarily measured by using a particular unit of time and which has a known beginning and a determinable end. The operative word is that, unlike a period or a duration which might be subject to contingencies such as age or election cycle, which can't be fixed exactly unless you are in jurisdictions like in the United States, where it is known that every 2 years, the first week of November has national elections, congressional elections, for example. If an election cycle is provided, subject to, and so forth, has contingencies, then it is a duration which is not, or which does not have a known beginning and a determinable end. Therefore, a term limit in this understanding is a cap on that non-beginning, a beginning which is known and an end which is determinable. As such, term limit provisions place a measurable lid on tenure with unyielding limits like non-renewable term, renewable once, not more than 2 terms, or total such as up to a maximum of 2 terms, or renewable once subject to competence and performance, and so forth. All term limit provisions in the Constitution, the 15, guarantee no endless or contingent extensions. They guarantee specific ends, not the kinds that are endless, open, or contingent. Fifthly and lastly, the following stands to reason from the foregoing. 1, the bill does not alter or change the presidential term limit in section 91, subsection 2. 2, there's no set term or the repeal of the presidential term limit. 3, there's no extension of the presidential term which can be done only in section 91, subsection 2, which is not included in the bill. 4, Sections 95, subsection 2B and 143, subsection 1 are election cycle provisions, and they are critical for that purpose. And they are found in all governments, systems governments, democratic, monarch, or communist, and so forth. They all define the period between the election of one president or head of executive and the next, or the legislature. It is crucial, not just as a matter of public law or constitutional law, but as a matter of civics 101, to know what is the election cycle of the government, the elective part of the government. It's an important civics lesson. And that's why, in our case, we didn't introduce these sections, 95 subsection 2B and 143 subsection 1 in 2013. We introduced them in 1980. We had them throughout the 37 Mugabe years. Why? Because for sections 95 subsection 2B and 143 subsection 1 are election cycle provisions, not term limit provisions, and they do not belong to the protected category of term limit provisions that require a referendum. 5, there is no implication arising from section 3287 because that section only affects term limit provisions and not non-term limit provisions, which are amended in the bill. 6, the bill only lengthens the election cycle from 5 to 7 years to break the toxicity of a permanent election mode in between elections. It's a Sabbath solution which everyone in Zimbabwe has had, from the churches who came up with a Sabbath proposal in 2021 to NTA who have their own Sabbath proposal, and it is in the body politic. The Sabbath proposal is in the psyche of any and everyone who has bothered to reflect on this proposal. It is not conjured up in thin or from thin air. And it is important to say that as far as election cycles are concerned, the minimum is 2 years for legislative people. And the maximum that is practiced by various jurisdictions as we speak is 10 years. 4 or 5 years is the medium, but there's a lot of literature, and at some appropriate time we will share this literature, which shows that many countries, African countries, which now are seriously grappling with the infrastructural policies and projects, which rely on presidential systems where there's the divisive direct elections and so forth, are reviewing this. We are not the only ones who are reviewing this. And recent as in September, last September, Guinea made this transition to 7 years. So the bill number 7, the bill is not about the president. It is about the presidency and about parliament as institutions, not members of parliament, not the president. And for the avoidance of doubt, in order to understand that section 95(2)B is not a term limit provision affecting the president. Consider this scenario. A presidential successor under section 101, following, say, a resignation of the incumbent or removal or a death of an incumbent after they've served, say, for 2 years. When that happens, the successor assumes only the remaining period of the term of the election cycle. If the election cycle is 5 years and the incumbent goes after 2 years, the successor just serves for 3 years. And this ensures continuity of the cycle without restarting the clock or a fresh term. This alone should settle the question that the period of 5 years does not belong to the office holder. It belongs to the office and can be held by many or several office holders. The same scenario is true in connection with a parliamentary by-election following a vacancy. In line with parliamentary term of office in section 143.1, the by-elections, they fill only the remaining election cycle time. One does not win a by-election to demand a full 5-year term. They win a by-election to serve a term started by the person who caused a vacancy for whatever reason but couldn't continue. I say again, if we are really serious, this should settle the question, because it's so clear that in both the case of the presidency, as described in section 95(2)(b), and in the case of parliament, as described in 143, we are talking about a term of office, not a term of officer. The terms of officers are described elsewhere. For the president in section 91, subsection 2, for parliament in sections 121, 125, and 129. For parliament, you don't find any term limit whatsoever. For president, you do, and it is in section 91, subsection 2. Parliamentary election of the president will therefore, in my view, as proposed in the amendment or in the bill, shield the office of the president from those ills which I summarized in terms of the twofold elements, which cause polarization, which paralyze policy making, breed endless disputes, and these have bedeviled our country with respect to presidential elections since the advent of those elections in 1990. And the indirect election will promote and strengthen national unity to give everyone and all communities, and I emphasize all communities, a voice in national governance through their representatives in parliament, in line with the section 3, subsection 2A of our constitution, which provides that the principles of good governance, which bind the state and all institutions and agencies of government at every level, include a multi-party democratic political system, which right now is at conflict, is not there. You can't have a multi-party democratic system when everything else speaks to it, but the most important office in the land doesn't do so. It creates a completely different process and structure. The direct election of the president is in direct conflict with the founding value and principle of good governance enshrined in section 3 of the Constitution. It is my considered view, therefore, Ndebele and non-Chancellor, as I conclude, that President Mugabe and his cabinet on this score of the bill deserve unqualified national commendation for coming up with the bill. It has taken quite some boldness. We didn't have it in 2013. People just made a compromise and took lock, stock, and barrel a self-evidently unworkable structure which has caused the government to have a constitutional commission in 2000. So on account of this progressive bill, in my opinion, we have to commend the government for coming up with it. In advancing the bold initiative, they've signaled a historic transformation that honorably reconciles Zimbabwe's troubled past with a promising future of real developmental progress beyond 2030. They are affected because they are the ones who are doing it, but it is the future players who are undoubtedly going to benefit from this and who will have the opportunity to improve it and make it even better. I thank you.
Well, thank you so much, Professor Jonathan Moyo. And guys, if you're just joining us here on this morning on Asake, welcome to the show. We are dissecting the legality of extending presidential terms. And you've just heard Professor Jonathan Moyo's arguments. And now I'll give the floor to Dr. Justice Mavedzenge to give his arguments as well. Dr. Justice, please do take as much time as you would wish. Over to you.
Thanks, Nonhlanhla. I hope you can hear me.
Yes, you're clear. Please do go ahead.
Fantastic. Good morning, good afternoon, good evening to your listeners, to Zimbabweans everywhere. I think some few preliminary points to just make, and I did not want to make these points. They were not in my original presentation layout, but because this is a debate, so I have to respond to what Professor Jonathan Moyo said. The first thing I want to sort of clarify is that it is true that these debates are not a preserve for lawyers. But we must agree out of decency as a society that people without legal expertise should not be driving something as serious as a constitutional amendment. It is like asking a lab technician or a nurse to perform a heart surgery. It's quite dangerous. And to be frank, part of the challenge that we have as a country is we have a whole minister of justice who has never practiced law anywhere. And I know that we are not the only country in such a situation, but that doesn't make it normal. So I just wanted to clarify that. Second point is I'm surprised that Professor Moyo once described President Mnangagwa as a leader whose core values are cruelty, sex, and money. And today he now tells us that such a person should stay longer in office, beyond his term, purportedly to address electoral toxicity. In 2018, recently, Professor Moyo wrote a book which I have here with me titled Excelgate: How Zimbabwe's 2018 Presidential Election Was Stolen by Jonathan N. Moyo. In this book, which I have read and used quite extensively in my scholarship, he exposes how President Mnangagwa stole the 2018 election. But also he says something about the President Mnangagwa's involvement in stealing previous elections. But today he says the same person is driving reforms to address electoral toxicity. One wonders what has really happened with the good professor, because his position is not in sync with what he has told us before. I am saying this not to attack Professor Moyo, but because he has invited us to congratulate, to embrace, to be excited about this raft of constitutional amendment proposals, because they are meant to address electoral toxicity. And it doesn't make sense unless Professor Moyo is able to then explain to us what has happened since he wrote his book in 2018 and other publications before. The other thing that I want to clarify is that I am participating in this debate because I have a precise objective to expose this planned constitutional coup, which is packaged as a constitutional amendment. Before doing so, I must point out that democratic space in Zimbabwe has virtually been closed down by President Mnangagwa's administration. We are therefore having this debate in a context where, one, those who criticize President Mnangagwa and his policies are subjected to threats of arrests, detention, torture, and even extrajudicial killings. A good example is the vicious threats that journalist Blessed Mhlanga has been facing for the past 2 days just for speaking out against government's repressive policies when he attended the Geneva summit. The second point which illustrates the kind of an environment in which we are having this debate is that vigilante groups, including one called Zimbabwe Anti-Presidential Criticism, led by a Mr. Andrew Pasinawako, have been formed and are allowed to continue harassing those who critique the president and his policies. Another example is the recent bombing of the SAPES Trust offices in October 2025, after a group of Zimbabwean civic and political leaders decided to hold a press conference to speak out against the now proposed constitutional amendments. And up to date, there is no progress in investigating the massive destruction of that property. Zimbabweans have established platforms to peacefully mobilize themselves against this constitutional amendment bill. So far, these platforms include the Defend the Constitution platform, DCP, and Constitutional Defense Forum, CDF. Members of both platforms are living in fear as they are constantly harassed and some arrested. In 2025, President Mnangagwa passed or assented to the PVO Amendment Bill, now PVO Amendment Act, which has virtually closed operational space for independent and organized civil society in Zimbabwe. So this is the context. And in this context, it is extremely risky to be engaging in this debate. And the risk is even bigger for those that are peacefully organizing the masses to speak out against this proposed constitutional coup. But nevertheless, we cannot afford the silence, especially in the face of what I personally regard as the biggest planned constitutional coup in the history of this continent. I'm happy to demonstrate with examples why I regard this as the biggest planned constitutional haste in the history of the African continent. But now let me deal with legal issues. The proposal to extend, first let's appreciate that there are a raft of propositions that are contained in this constitutional bill. It is my respectful view that a lot of those other proposed amendments are just an attempt to divert our attention from the real thing. The real thing is that the bill seeks to extend the president's term of office without holding a referendum. And this proposal is both legally and politically problematic. And I will demonstrate why. President Mnangagwa and the proponents of this bill are seeking to amend the constitution without following a due process. And we are once again witnessing attempts to mutilate the national constitution in order to manage ZANU-PF's internal succession crisis. I need to emphasize that particular point because it responds to the kind of propaganda that we have been exposed to up until now as to what is the purpose behind this constitutional amendment bill. The purpose is to manage ZANU-PF's internal succession crisis. So our national constitution is being mutilated, just as we saw how the constitutional institutions were subverted under President Mugabe in order to deal again with an internal succession battle. And that led to the 2017 military coup. And I think it is important for Zimbabweans to keep that at the back of their minds, that the real purpose behind this bill, the real purpose behind this planned constitutional coup is to simply manage the internal ZANU-PF succession processes. Section 328, subsection 7 of the Constitution lays down a very clear framework for deciding whether an amendment to the Constitution should be done after a referendum or not. And the framework is this: if an amendment seeks to A, change a term limit provision, and B, has the effect of extending the length of time that a person may hold a position, then the amendment must be subjected to a national referendum and cannot benefit the incumbent. The bill presented before us seeks to amend Section 95, subsection 2B of the Constitution by increasing the term of office for the president from 5 to 7 years. This is not my interpretation. It's what is written in the bill, to increase the term of office for the president from 5 to 7 years, and to allow the current president to continue in office beyond 2028 until 2030. This is what is in the bill. Then the question is, is Section 95.2, which is expressly targeted in the bill, is Section 95.2b a term limit provision? The short answer is yes. How do we know that it is a term limit provision? I will give you four reasons here that are very clear, some of which have been, in my view, distorted by Professor Moyo. Whether it's deliberate or it's unintentional, I don't know. Section 328 defines a term limit provision as follows, and I want to quote, because I think when we have a situation where people are attaching their own definitions to things, we need to quote the exact provisions of the Constitution. So Section 3281 says, open quote, a term limit provision is a provision of this Constitution which limits the length of time that a person may hold or occupy office. At this point, it is critical to clarify that a term limit provision is not about the number of times that a person may hold office necessarily, but the length of time that a person may occupy the office. Again, go back to Section 328. It's a provision of this Constitution which limits the length of time that a person may hold or occupy a public office. Section 95 2B defines the length of time the president can occupy that office. It sets the term at 5 years. I don't know why there's confusion about this. But let's move out of the constitutional text a little bit. If you ask any Zimbabwean in any village, in any street, if you ask them this question, when are elections in Zimbabwe due? They will tell you that elections in Zimbabwe are due every 5 years. So why do we hold elections every 5 years? It is because the term of office for the president is limited by Section 95 2B to 5 years. We do not hold elections every 5 years because of Section 91.2. Because there is nothing in Section 91.2 which says elections are due every 5 years. Let's read it together. Let's go to 91.2, because we must cite these provisions as they are, so that we avoid confusion. Section 91 says, the title is Qualifications for Election as President and Vice President. Mind you, the title of that section tells you what it is about. It is about qualifications. But let's go into its substance. Subsection 2, it says, open quote, a person is disqualified for election as president or vice president if he or she has already held, open quote, a person is disqualified for election as president if he or she has already held office as president under this Constitution for 2 terms, whether continuous or not. And for the purposes of this subsection, 3 or more years service is deemed to be a full term. Where does it say 5 years in that provision? There's not. It doesn't define the full term of the president. I will later show you what the purpose of 91.2b is. But at this particular point, I just want to deal with this propaganda that says the term limit, the only term limit provision for the office of the president is Section 91. If that was correct, and if someone says, why do we hold elections every 5 years? The answer is not in Section 91. The answer is in Section 95. So that already tells you that Section 95 is the term limit provision. Now, it is for these reasons that the Constitutional Court in Max Mupungu versus Minister of Justice has already identified Section 95 as a term limit provision at pages 50 and 51 of the judgment. But let me talk a little bit about Section 91 too, because that is where a lot of propaganda is circling around. In an attempt, you see, when people are planning a coup, they first deploy propaganda precisely to mislead and confuse people. We have seen this in Zimbabwe. Whenever electoral coups have been planned, the first attempt was to criminalize opposition. The first attempt was to mislead Zimbabweans into believing that the opposition is some kind of a creature that should never be allowed to take over power. Right. Fast forward 2017, when a coup was being planned, we were told that the purpose of this whole operation is to remove criminals around the president. This is the same tactics are being deployed here to say, look, the real term limit provision is Section 91(2). So I've already told you that the real term limit provision is 95, and I'm not alone on that. The Constitutional Court is with me because there's a decision which says 95(2)(b) is the term limit provision. But let me show you what 91(2) is about. The argument of those that are sort of lobbying for this constitutional coup is that Section 91(2) is the term limit provision, while Section 95(2) is not a term limit provision. And therefore, as long as the amendment is not targeting Section 91(2), it does not need a referendum. The title for Section 91(2), as I said, is qualifications for election as president. That particular provision goes on to say a person is disqualified for election as president if he or she has already served as president for 2 terms. 2 terms of what? You can only answer that question if you go to 95, which is the mother of presidential term limits. 91(2) then goes on to say, to define what makes up a single term. So of these 2 terms, a single term is 3 years and above. So what basically we have here is a scenario where Section 91(2) is explaining and expanding on the term limits that is defined in Section 95. So Section 95 is the cathedral for presidential term limits in Zimbabwe. It is the primary provision that limits the term of office, and it does not need, in Professor Moyo's language in the past, it does not need a rocket scientist to know that, because we have elections every 5 years. The president cannot go beyond 5 years. If actually you go to the other judgment of the Constitutional Court, Jelas Mawarire versus the president of Zimbabwe, I mean, I think versus Robert Mugabe. The Constitutional Court has already indicated again that the term of office is limited to 5 years. It is limited to 5 years. So you can't create any fiction around that in light of existing jurisprudence in the country, but also practice. Yesterday, it's true, what Professor Jonathan Moyo said. Yesterday, the Attorney General's office published what I consider to be a mischievous and misleading flyer, which says the only term limit provision for the president is Section 95. You see, I can understand when persons without basic legal knowledge fail to make a connection between Section 912 and Section 995. But I struggle to understand how a whole Attorney General's office can miss this. It has left me with two questions, and I'm sure that those are the questions that other Zimbabweans would also have. Is the Attorney General afraid of telling the President the truth that the term limit provision is primarily Section 95(2) as per the Constitutional Court's decision? Or is the Attorney General complicit in these sinister plans to subvert the Constitution? Now, let me jump to the second last part of my presentation. A lot has been said about this decision in Max Mapungu versus Minister of Justice. Part of what has been said is to mislead the people who actually are the owners of this constitution. The owners of this constitution is not ZANU-PF, it's not me, it's not any of the politicians. So one of the arguments that I've heard against this decision is that, well, what the court said in Max Mupungu is obiter and is non-binding. Okay, let's break this down for purposes of our colleagues who may not know what obiter dicta is. Obiter dicta is a Latin term which refers to comments or observations that are included in a judge's ruling, and those comments are not essential to the decision. That's number one. They are not essential to the decision. Number two, and as a result, they are not legally binding on other courts. In other words, obiter, friends and colleagues, simply means a suggestion. You know, the court was just making a suggestion or was just making a passing comment. Now, let's go to this judgment that I talked about, the Max Mupungu judgment. In this judgment, the court was addressing the question whether the decision by the president to extend the age limit from 70 to 75 years for the Chief Justice should be regarded as an amendment to the term limit provision. The court drew a distinction between age limit provisions on one hand and term limit provisions on the other hand. Now, age limit provisions are those clauses in the Constitution which limit the oldest age at which one can occupy an office, while term limit provisions are clauses which limit the length of time one can occupy an office. So the distinction is age limit is about age. Term limit is about length of time. In making this distinction, the court did not just make a passing comment or a mere suggestion that when it identified Section 95(2) as a term limit provision. It made a binding ruling which simply says, and this is the point, you can change age limit provisions, but you cannot touch term limit provisions without seeking the approval of Zimbabweans. And that distinction in the context of that ruling was essential. If, in fact, the whole argument in that court application, the whole argument was centered around the distinction between age limit and term limits. And the decision of the court turned on that distinction. And in explaining that distinction, the court had to demonstrate what are term limits and had to demonstrate what are age limits. And then someone wakes up from somewhere and says, no, the court was just making suggestions. It was obiter dictum. Listen, I can understand if this is coming from a first-year student of law, because usually we don't go that deep in explaining to them legal concepts. But I worry when I hear that coming from someone who is at the level of a minister or a former minister who has dealt with the law. It is worrisome. Now, the other thing I want to draw your attention to is the language used by the court in delivering this ruling. It is emphatic. It is not a suggestion. Let me quote it in verbatim. The court said, open court, as is self-evident, the tenure of all of the aforementioned public office, including the president, is undoubtedly subject to term limit provision within the meaning of section 3281 of the Constitution. Colleagues, when the court says something is undoubtedly, that is no longer a suggestion. Okay, if you're, let me just draw this analogy. If your mother says to you, you must never eat food from our neighbors, do you think your parent is making a suggestion to you? Your mother is not making a suggestion to you. They are telling you what you must do and must not do. You can't just wake up and say, no, my mother was suggesting things because she suggested these things in the context of another discussion. Law does not work like that. But like I said, I would totally understand if I'm confronted to this kind of an argument from a first-year law student. Another misleading aspect that has been propagated about this judgment is that this judgment was written by an excitable judge. Again, I would understand if that is coming from someone who has no knowledge of the law, but not even a first-year law student can say that, because when you read the judgment, you will see that there are two judges who wrote the judgment, or rather who led the writing of the judgment. That is Justice Rita Makarau and Justice Bharat Patel. Then when you read at the end of the judgment, there are 5 other judges who have signed that judgment to demonstrate that they associate with the views and the findings that are in that judgment. And none of them wrote a dissenting judgment. You see, when you go back to the 2017 Jelas Mawari versus Robert Mugabe case, about which also dealt with the question, when are elections due? You will see that there was a lead judge who wrote the judgment. If I am correct, it was the former Chief Justice Chijika Osigu. But you will see that other judges signed, but you will further see that Justice Bharat Patel and the then Deputy Chief Justice Luke Malava wrote their own separate judgments, where they clarified areas that they disagreed with the ruling and areas where they agreed with the rulings. In the Max Mupungu decision, there is no dissenting judgment. There is no separate judgment. All of them in the Constitutional Court associated with the findings in the judgment. So how does one wake up from somewhere and just say, it was one judge. First, it's not one judge, so that's a lie. Secondly, you can't say it's a judge who was just excited and is not harmless for what we are trying to do. No, it's very harmful for what the government is planning, because the court has already taken a position on this matter. And it will be very, very concerning if the Constitutional Court climbs down from that position, because it would simply send a message to Zimbabweans, but also to the whole world, that this court makes decisions depending on who is before it, as opposed to depending on which issues have been pleaded. Lastly, I started with politics. I want to end with politics, because we must understand these things in a political context. And that is the only way we'll be able to then detect and address some of the propaganda that is being churned out. This constitutional amendment does not make sense politically, because the Constitution is the legal basis for a social contract between the people and their government. The president and the MPs and members of parliament were all elected on the basis that they would serve for a maximum of 5 years. That is the basis on which they were elected. Section 95. You can't run away from it, because that's what it says. It only makes sense that those members of parliament and the president should go back to the people and ask for an extension of their term or their time in office if they think that they are doing a good job that warrants them to stay longer in office. This is why you have section 3287 in the Constitution. It is there precisely to avoid situations where people are elected into office on the understanding that they will spend 5 years. And then while they are inside, they then abuse the power of incumbents to extend their time in office without going back to the people who elected them in the first place. I think there's a member of parliament, forgotten his name, who gave an illustration which I thought makes sense in this situation. He says, imagine an employee, you hire an employee to serve in a position for a period of a year, and towards the end of the year, that employee decides to extend their own contract because they think they are doing a good job. I think that captures the essence of what we are dealing with right now. But why is it that, look, if you are trying to deal with electoral toxicity and you are well-meaning for Zimbabweans, and that's why you are coming up with this constitutional amendment bill, why are you so afraid of going to a referendum? I think we know why the proponents of this bill cannot afford to go to a referendum. I think they know that they've done a terrible job, and they are not confident that if they go to a referendum, the people will grant their request. I don't think so. Why? I would like to draw your attention to a survey that was done by Afrobarometer quite recently. Cumulatively, 52% of respondents are not happy with President Mnangagwa's performance. Another anecdote is that Zimbabwe has been ranked 22 out of 100, meaning that it's the 22nd highly corrupt country, according to the 2025 Anti-Corruption Perception Index. According to the World Bank, 49% of Zimbabwean population live in extreme poverty. I don't need to explain this one any further, because all of us in this virtual room are experiencing this either directly or indirectly. But just imagine 50% of the people in the country are living not just in poverty, but in extreme poverty. civil servants earn as little as $250 per month. And to add salt to the wound, in that context, you have a government that prioritizes, or rather, you have a group of political actors who prioritize buying high-end luxurious vehicles and donating them to celebrities, donating them to political actors, in a context where more than half of the people in the country are living in abject poverty. That is highly insensitive. And in such a context, it is highly unlikely that President Mnangagwa can win a referendum to extend his term of office. And that is exactly why the only way he can get an extension is by sidestepping what the Constitution already says. And by the way, as I mentioned earlier on, this is not the first coup that we are about to witness. There are several coups of different types that we have witnessed in Zimbabwe. I've already mentioned to you the electoral coup of 2018, which I hope Professor Moyo will not disagree with me, because he has written about that coup. The second electoral coup, noticeable electoral coup, was in 2008, where they disappeared with election results for a whole month and only published doctored results, which were rejected by SADC and other stakeholders, leading us to a government of national unity, which then led us to the constitution, which they are now trying to topple. In 2017, they lied that they wanted to remove criminals around former President Mugabe. Yet the real issue they wanted to achieve was to capture the state and replace Mugabe's criminals with their own criminals. And now in 2026, they want to stage another coup, but this time against the constitution. Now, I will end by saying this, because I know that in the virtual room are people from the African Union, from SADC. A fundamental problem that the African Union, particularly under the chairmanship of President Ramaphosa and I think the president of Angola, we're trying to deal with, is the problem of unconstitutional changes of government. And the Peace and Security Council of the African Union has flagged this as not just a challenge or a threat to democracy, but a threat against the potential of the continent to integrate, and consequently a threat even to the agenda to establish a free trade, common free trade market covering the entire continent. Now, there is a relationship between military coups, which we have seen on the rise quite recently. The latest one being in Madagascar, toppling President under Rajolina, former President Rajolina. There's a relationship between military coups and electoral coups and constitutional coups. What normally happens is that leaders engage in a constitutional coup to remove term limits so that they can remain in power without without seeking the approval of the people. The duty is not to consult, by the way, it is to seek the approval of the people. So they do that without the approval of the people. Then they get into an election and then steal the election, which is an electoral coup. Now, once they have done that, what these leaders don't realize is that they have become vulnerable to a military intervention. And that's what normally happens. When you look at what happened in Gabon, that coup took place I think a day or 2 days after the then president had thought he had successfully rigged an election. It's the same thing in Niger. It's the same thing in Madagascar. But one can also say it's the same thing that happened in Zimbabwe. After President Mugabe lost the 2008 election and later on performed an electoral coup, or rather allowed those around him to perform an electoral coup so that he could remain in power, he became vulnerable and beholden to those that had helped him to perform an electoral coup. And since that time, the risk for a military coup in Zimbabwe was always high. I don't think it is in our interests as a country to be perpetuating that kind of a scenario. So if at all there are people in this government that are interested in addressing political or electoral toxicity, the first thing that they should do is to respect the constitution, but also to respect those whom they govern. I will end there for now, and happy to deal with whatever question that comes.
Okay, thank you very much, Dr. Justice, for that. If you are just joining us, this is Asake Online site. It's an interesting debate. The two gentlemen who challenged each other on Twitter, and then they are resolving it here in the site. We are happy to host that. If you are still here, please don't forget to follow us. So for now, like round two, we are going to, maybe I'll have one question, Nonsense, I'll have one question. That will allow the two gentlemen as well to, respond to each other's arguments. And we'll give this chance to Prof to answer the question that I'm going to ask, and also to respond to some of the issues that Justice has raised, and we'll do the same to Justice. So Prof, in responding, maybe my question to you is, you mentioned issues around the Zimbabwe's electoral impasse, and my question is, the electoral impasse, is it because of short terms, or is because of contested processes that need electoral reform? Over to you, Prof. Your mic is mute. Okay.
Sorry, yeah. Well, thank you for your question. But before I deal with it, it might be that I will deal with it in the remarks that I'm just about to make. But before I do, I would like to first deal with the anecdotal discourse that we've just heard, disguised as a discussion on the amendments as proposed in the bill, when in fact it is anything but about the bill. From that discourse, you will not understand what the bill is providing, what the real contentious issues in the bill are. You would even think that the discourse about the bill has to do with the Mupungu case. It sounded like the usual tutorials we get from some of our compatriots when weighty national issues are before us. The first thing they do is to do exactly what Justice did, to deal with the speaker and say, in 2018, you wrote this book and criticized Mnangagwa for stealing the 2018 presidential election. And now you are saying the same Mnangagwa who you criticized must be congratulated or commended for putting forward the amendments that are before us. For me, quite frankly, much as we are told that this is like classroom and first-year students and so forth, I guess those who are still teaching undergraduates, first years, mischievously continue to consider their colleagues in society their students, that they extrapolate the behavior of their students and the manner that they talk with their students, and they bring that to serious discussions such as this. And that is exactly what was happening in the presentation. And I think this is unfortunate, because even those who share the same views with a good doctor would come out none the wiser about what the bill really is providing. And really, I think the idea that someone comes to a platform like this and uses psychodrama to criticize people who are not here and make it appear that the real issue that should preoccupy the nation and the body politic of Zimbabwe is that Minister Ziyambi has never practiced law, and make a mountain out of that anecdotal observation, I think it's pretty juvenile. And I think this is one clear example of what is wrong with our country. For me, it reminds me of the experience we had in 2000 with the draft constitution. A draft constitution which was dealing seriously with structural issues of governance and institutions of governance which had been experienced up to that time, and seeking to correct a building on what had worked out of our experience and noting what had not worked, was reduced into this kind of discussion. It is exactly this sort of approach where the whole thing is turned into a juvenile debate, attacking human beings or other people as if dealing with those people, if you can deal with them, will make a better constitution. In 2000, it was about Mugabe. Let's forget what the draft constitution is actually providing and how it is gripping the national questions that are facing the country, and look at the behavioral traits of Mugabe and make sure that we don't allow Mugabe to use this draft constitution to settle the succession question in ZANU-PF, which question from these colleagues of ours is always there at every juncture. When a serious national issue comes, the deflection is no, let's not entertain it. Because if we do so, we'll be participating in ZANU-PF succession politics. ZANU-PF ever unending succession politics. And so what do you get in 2000 as a result of this kind of attitude? A systematic refusal to engage in issues and create drama around individuals and deflect, instead of talking about the constitution, or rather the bill with the amendments. Let's talk about military coups in Africa. What has that got to do with the bill? And are we any wiser after listening to this, other than that there's somebody who is speaking and listening to themselves and addressing a particular gallery that is well known? And if you get this sort of thing as happened in 2000, you will get a material result. In 2000, it was throwing the baby with the bathwater. And an opportunity was lost, and the Mugabe, who was said was the problem and needed to go when it was done, and when we had entertained this kind of anecdotal discourses, Mugabe was in office, and not only in office, until 2017, and not removed by the people who championed this kind of engagement, but by completely circumstances which are different. I think the country has a choice, either to mature like other countries. And those from the African Union or other neighboring countries with an important role, including from SADC itself, should use this as a lesson. This should expose them to the kind of engagement that those who posture as the champions of the alternative take when they are engaging. They will remind you about your mother. They remind you about your girlfriend. They will remind you about the Gananda and the monies that they are spending, and say that this is constitutional discourse. And they will shout in the same way they do in classrooms and pretend that what they are shouting and asserting is the truth. Surely it can't be the truth that Section 95, subsection 2 is a term limit provision just because the good doctor is saying so. It cannot be. He has to make substantive arguments. Now, I will say this about his preliminary characterization of me. If President Mnangagwa says today is Thursday, I'm not going to disagree with him because I criticized him in 2018. The idea that human beings do not change, that human beings today are what they were yesterday, is a juvenile idea. You will not find it in any serious environments. Marco Rubio would not be the Secretary of State for Donald Trump if the way they interacted yesterday or 4 or 5 years ago was the basis of how they should interact with each other today. One of the problems we have in Zimbabwe is the failure to break the walls, the barriers that divide us or that divided us yesterday, in order to find each other today and engage each other as rational human beings who are not seeking to score easy political points through rhetoric and are afraid of confronting the real issues that affect ordinary people in terms of their livelihood. So I'm not going to, I understand only too well that politics and political engagement is not an individual odyssey. It's an interpersonal engagement. It's a group engagement. And good politicians are not those who bury their heads in the sand and use yesterday to refuse to engage with their compatriots today. But those who use opportunities as they are presented in the public domain to engage with their compatriots and turn the page. Now, I would like to deal with, and in this way answer perhaps your question, but still dealing with the presentation that has just been given. It is correct that we should ask the question, why do we hold elections every 5 years? I think that is an instructive and important question. It is incredulous that anyone can say the answer to the question why we hold elections every 5 years is because the 5 years is a term limit. There is no logical or rational basis for drawing such a conclusion. The self-evident and obvious reason which is linked to the bill is that we hold elections every 5 years because we have always held them every 5 years. And we have done so since 1980, not since 2013 when the so-called term limit provision was introduced. We have held elections since 1980 because they define the start and end of our government. That government is elected, or up to now, has been elected for 5 years. And the fact that government has been elected for 5 years since 1980 does not constitute or define a term limit and cannot be used by a rational person as an example of a term limit. We've been holding elections every 5 years, therefore that is a term limit. That is outrageous. We have been holding elections for 5 years, every 5 years since 1980, because among the three arms of our government, the executive arm and the legislative arm are elective. They are elected. And their need to be elected has been with us right from the start of our independence. And the sections that have defined that process requiring us to have elections every 5 years has been in our constitution since 1980. It was put with respect to the presidency, although it was a ceremonial president when we started, it was put in section 29 of the Lancaster Constitution. And with respect to parliament, it was put in section 63, subsection 4 of that. And those two sections, 29 with regard to the presidency and 63 with regard to parliament, have remained like that, defining the length of the presidency as an institution, not about of the president as an officer, as a holder of the office of the president, and the parliament as an institution of parliament. This is done by all legislatures and executives around the world, many of which don't have term limits. And quite frankly, those who want to hoodwink Zimbabweans and who think that propaganda is done by other people and what they are telling is nothing but the truth because they fancy themselves as truth tellers, have to explain to Zimbabweans how does something that we've been doing for at least up to 2013, without it being the term limit, because what we are being told now, which is quite outrageous, is that the definition of these offices, the presidency, as per section 95, subsection 2B, or previously as per section 29, is a term limit, and is the only term limit. And that section 91, subsection 2, is just about the qualification of the president. So if we've had the term limit all these years, why did Mugabe serve for 37 years? Why didn't he leave? And going by this logic, Mugabe should have left office having first elected as president since before amendment number 7, he was prime minister. He was elected under a section exactly similar to 90 subsection 2. That is section 29 of the former constitution. He was first elected in 1990. And if this logic, if you are going to call it that, is the applicable one in terms of defining a term limit provision, then why wasn't Mugabe limited by that provision? And the answer why he was not limited by that provision, yes, does not require a rocket scientist. It's simply because it is not a term limit provision. It has never been a term limit provision and has never been considered by any country when they are as a term limit provision. The Americans, right from 1788, they had a provision similar to section 1995 subsection 2B in Article 2. That provision never limited US presidents until in 1951, when they had the 22nd Amendment, which expressly limited that office by saying no one shall be elected to the office of the president more than twice, for more than 2 elections. In the same way, section 91, subsection 2 is doing. No one shall be, just like the other one is a disqualifier, 91 subsection 2 is also a disqualifier. And a term limit provision by definition is a disqualifier. If you want to find a term limit provision in any constitution, let alone ours, you look for the disqualifier. You don't look for a definition of the length or period of that office. The introduction of the term limit provision in Zimbabwe came for the first time in 2013 as a disqualifier. You cannot do this if you have done this. You can't occupy this office if you have served. And the 3 years, that is in section 91, subsection 2, is not a definition of the length of the office or the length of time in that office. It's a definition of the minimum that constitutes a term for purposes of disqualifying you. If you have served in it for 3 years, whether continuous or not, and there's another portion which also has that threshold, you cannot serve in that office. And section 328 subsection 1, which defines what a term limit provision is only applicable to the disqualifier. It is not applicable to a definition of a period which was well developed. You say that the Mpungu judgment was about age limits and versus term limit provisions, and you are quoting it with pleasure, when you in fact rejected that interpretation of the court in 2021. It is common cause that the whole lot of you who are now trying to twist the interpretation of the Mpungu judgment, first celebrated the High Court judgment, and secondly, you denounced the ruling by the Constitutional Court because you said the age limit is a term limit provision, just like the High Court said. Now you are trying to pretend that you are a friend of the Constitutional Court, Justice Patel and Justice Makarau, who wrote that judgment, and you the same person who is interested in what people did and ate, who they slept with 25 years ago in order to judge whether they can participate in meaningful conversation today, is not bothered by the fact that you're not. He didn't agree with the Constitutional Court. You still don't agree with the constitutional today, the court decision today. You think that the age limits as were provided under Section 186 then and now is a term limit provision. In the same way, you think that the definition of the length of the presidency as an institution or the duration of parliament as an institution is a term limit provision. You did not understand that the court says a term limit provision has a specific beginning which is known and a determinable end which is also known from A to Z. And in the case of the judges there, the court said the term limit provision was the clause saying that judges are appointed for a 15-year non-renewable. That is very clear in terms of its beginning and in terms of its end. As clear as the provision in Section 91(2), that if you serve for a minimum of 3 years, or rather, it actually says if you serve for 2 terms, the term limit of the president is 2 terms. And that limit is put in Section 91, subsection 2, and it says if you serve for 2 terms, you cannot serve in that office again. And for purposes of this section, a full term is 3 or more years. It doesn't say 3 or 5 years. It says 3 or more. It doesn't define the upper limit. It doesn't define the maximum. Because going by your logic, a person can only serve for 10 years. But you know that a person can start their term if they are succeeding somebody else, and their assumption of that office comes, say, after the predecessor had served for 3 years. They can serve for 2 years, and those 2 years will not count as a term in terms of the disqualifier. And they can have their own fresh terms and serve for 5 or more years, because no term ends at 5 years exactly, which is why this is not a term limit a la Mupungu judgment. The end of that term is not 5 years. It depends. It extends until a host of possible events can have taken place. And therefore, if a person serves for 2 years to complete a previous term, and then they serve 5 years, they will have 12 years. Yet, going by your logic, no one should do that. Everyone should serve 10 years. So, Nontanda and Debele, I have a problem to deal with people who think that when we are facing national questions such as this, it's an opportunity to continue our political differences. And we are incapable of bracketing their drama about our political differences and what we think about it. A person who comes and starts talking all stuff of a personal nature about an individual doesn't have a monopoly to do that. We can all do that. But if we all follow that kind of approach, we will not solve the problems that are before us. For me, my problems or issues that I had with President Mnangagwa yesterday do not stop me from appreciating the institutional, transformational decisions he may do today, as is the case with these amendments. They are transformative. They are serious. I can't, one thing you misrepresented Zimbabweans by saying, if you ask them, why do we hold the elections every 5 years? They will say, we will do so because that's what the term limit is. No. You do yourself, I think, in my opinion, a great service if you focused on the substance. For example, you say that the Mupungu judgments part, which includes section 95, is not obiter, and to characterize it obiter is somehow to insult the judges. I'm going to read for you to show that this is obiter. It can't be anything but obiter. That paragraph starts by saying, by way of contrast, the Constitution abounds with a myriad of provisions that unquestionably constitute specific term limit provisions within the parameters of Section 3 to 8. There is no debate that the true term limit provisions that are as defined by Section 328, subsection 1, are unquestionable about the parameters of what constitutes a term limit provision. That's true. And there's no one who has challenged that. But then it's the paragraph goes on. First and foremost, there's Section 95(2), which expressly stipulates that the term of office of the president is 5 years and coterminous with the life of parliament. With the greatest of respect, and we are not prisoners of what some other people write, that sentence is not correct. It is not correct, objectively speaking, that Section 95, subsection 2, says that the term limit of the president is limited to 5 years and coterminous with the life of parliament. Because it says more than that. It says extends until, and the extension until goes beyond 5 years. And there is a proviso which acknowledges that it can be more than 5 years. There is not a single a term limit provision. You take the term limit provisions that the Attorney General published yesterday, and you are entitled to say it was missing one, but those that are included are in fact term limit provisions, and all of them have a common genus. The genus is the requirement to be specific about what the limit is. You must find the limit in those provisions that were outlined, but you cannot find that limit in Section 95. In fact, one unique quality of Section 95, which it shares in common with other similar term length provisions in different jurisdictions, whether South Africa, whether Botswana, whether the United States itself, is that they don't have an identifiable limit. They don't have there are three essential elements of a term limit which are absent in such provisions, but which are present in the rest, where the judges says, then there are others. There's Section 197, which provides that an act of parliament may limit the terms of office of the chief executive officers or heads of government, and they do. Or Section 205, subsection 2, the term of office of permanent secretary is a period of up to 5 years and is renewable only once. Yes, as regards the defense forces, Section 2163 states that the commanders of the defense force and their services are appointed for a term of no more than 5 years. Yes, it says that you are appointed for no more than. There is no more than or non-renewable in Section 95, and then with reference to the police, the intelligence services, and prisons and correctional service, Sections 221, subsection 2, 226, subsection 2, and Section 229, subsection 2 provide that the respective heads of these services are appointed for a 5-year term, which may be renewed once. Why doesn't Section 95 say the term of office of the president is 5 years, which may be renewable once? That would make it a term limit provision, because that's what a limiter or a caper does. It is absolutely absent there. and then it says, provide that the respective, that's the one I read. Next, there is section 2385, which stipulates that members of the Zimbabwe Electoral Commission are appointed for a 6-year term and may be reappointed. So why does the other one not say that the president may be re-elected for another term, may be reappointed for one such further term? Similarly, by virtue of section 2594, the term of office of the prosecutor general is a period of 6 years and is renewable for one further such final term. And lastly, the section 3110.3 provides that the term of office of the auditor general is a period of not more than 6 years, up to one or more periods, not exceeding 12 years. You know, the fact that you are a lawyer does not render the rest of us idiots. And it does not mean we should rely on you to read very clear language. Section 328, subsection, I think, 2, says if you are making an amendment, and you can read the same if you are making a constitution and you are drafting a constitution, what you are doing must be said in express terms. It must not require a rocket scientist to tell anyone who wants to find out what it is saying. Nobody requires a lawyer, a lecturer to understand what the Constitution says. And when the judge was interpreting Section 328 against Section 186 in the case of judges, he made a very important observation that constitutional provisions must make ordinary grammatical sense as conveyed by dictionaries. They don't require some guy who wants to swindle people of their money because he's a lawyer. They require the simplicity of a dictionary. And the explanation of what a term limit is in this judgment is of the kind that every grandmother can read and understand. And this insult of first-year students, non-lawyers, is unbecoming. It's actually outrageous for a mature person who wants to be taken seriously and to convince those who may disagree with him. So this part of the judgment quite clearly includes Section 95, which has nothing in common with the other 6 sections. The other 6 sections have a common genus. They say this many years renewable once, this many years not renewable, this many years up to a maximum of this. That is a very important qualifier of a term limit provision anywhere in the world. Take the South African term limit provision, which is separate from the term description or duration provision, the Botswana, the American one. You will find that the genus has a differential which distinguishes them so that you don't call every provision you find that includes time or defines time, you call it a term limit provision for that reason. And I must say, your propaganda that this is a constitutional coup is fine with your audience. And at least one thing that propaganda does, and propaganda is what it is, what it does, at least it concedes that when you say something is a constitutional coup, you are agreeing that it is actually following the letter and spirit of the Constitution. You are conceding that it is at least technically correct. And then you are saying it is being used, the technical correctness of it is being used to advance other purposes. But for someone to convince a rational person that a president who is exiting is pushing a personal agenda or is self-dealing, as the expression goes, by through his cabinet tabling before Parliament for its consideration a bill that disrupts a problem that has been acknowledged by everyone. You say people who you ask them why do we hold elections every 5 years? Well, ask people, are you happy with the elections we hold in directly electing a president? Many of them, including the majority in your group, are now saying the elections do not deliver anything. The only thing they deliver is quarrelsome, toxic politics in between the elections, and they are disputed. Every presidential election, unlike every constituent election, has been disputed since 1990. And one of the reasons we did not become a one-party state was because of the challenge to those elections in 1990 by Edgar Tegere and his Zoom. And the challenge was violent, or there was violence, political violence. And that has happened with the presidential election throughout up to now. And we have reached a position or point where some political players even don't want to contest in Parliament because they think the big deal is this one office. But that one office, by having it through this current arrangement of direct elections, has brought our country to a standstill. A more objective assessment of our country is that the way we choose a president, as opposed to the way not only South Africa and Botswana choose their president, but the majority of the Commonwealth choose their executive, is inherently problematic. And that problem needs someone who is bold to deal with. And we cannot say, if President Mnangagwa today says, no, I'm going to deal with this problem. And I agree that the way we created the executive presidency in 1987 created problems which we have not anticipated, which we have seen. And before we put this, we were better off. And uses the same logic that was at play in 2000 and says, let's solve this. It will take an unreasonable person. And there is a standard of a reasonable person and an unreasonable person. An unreasonable person will refuse to come to the party to deal with the problem, claiming that, but you stole that election last year, you did this and you did that, and refuse to take an opportunity to solve the problem. What is worse about an unreasonable person? Not only will they take down a substantive initiative that solves something that has burdened us for a long time, they will actually offer no alternative. They will say, rather than dealing with this system and solving the system, let's deal with these human beings and their behavior. We can solve this problem if so and so and so and so and so and so change their behavior, and they allow this and allow that. Then we won't have problems with elections. There is no student of public administration, no student of even public law will take that kind of a position, because it is an inherently ridiculous position. It refuses to search for systems that will assist us to create different conditions. It will create people who bring anecdotes to shoot down an opportunity for other communities in Binga, in Mzarabani, in Wonde Valley, throughout the country, to elect their representatives as communities, as constituencies, send them to Parliament, and let them work with other representatives from elsewhere in the country to choose a president. Rather, they will either insist that, no, let's continue. If the people in UMP always vote for people who come from their area, which they will do, it doesn't matter. This is the system that we have. Or they will say that is not the problem. The real problem is the behavior of so and so and so and so. If you get rid of the Gananda, we will make some progress. Or ningi na ningi na ningi. I mean, we can't believe that people who are in academic institutions really want to have these kinds of juvenile debates in serious platform and refuse to grip what is clearly and unquestionably, to use the language of Justice Patel, clearly and unquestionably a problem in our body politic. I want to end by being more specific in response first let me say, it is a complete lie, and it does not become a truth because some lawyer is claiming it. It is a complete lie that this question of Section 95, subsection 2, in relation to term limit provisions was decided by the court. It's a remark in passing precisely because that was not the issue before the court, and the court did not have arguments before it to marry more to settle that question itself. Luckily, various applications have been brought before the same court raising that question, and I don't know why some people who think when they say this is a term limit provision, make a lot of noise, raise a lot of bluster and dust. They themselves are not trying to tie the court's hands to say, hey, don't climb down. Climb down what mountain which they didn't climb up? You know, why are you okay in making that kind of outrageous comment? And those who say, no, but this is a remark in passing, it was obiter, should not do this. Meanwhile, you want to present yourself as a Democrat. You should say and wear your jacket and with colors and say, I'm a lawyer, and use your being a lawyer to disqualify other people who have an equal, at the very least, interest. But make outrageous comments which are designed to politicize and gag the court by claiming that it has decided a matter that was never argued before it. You know, it's a very important matter. It cannot be argued, rather, it cannot be settled as a by the way. Oh, but and then you throw up something and you throw it in a basket where it actually doesn't belong. And you haven't made an argument here, you know, on a matter that is so rudimentary. You have not made an argument that Section 95.2 has a limit. You have simply called it that. It reminds me of some people, academics, who instead of getting into what theory is, and the theory must follow practice empirically, they simply declare something to be theory. They don't go through the process of reasoning such that a rational person who is independent can relate to the argument and say, okay, I'm looking at this judgment, I'm looking at this provision, and I've been told that a term limit provision has the following features. You did not even give one feature of a term limit provision, which someone who is listening to you can go alone on their own elsewhere and read these constitutional provisions and say a constitutional provision by definition following Section 3281 must have this feature. And if this feature is absent, then it is not a term limit provision, no matter what anyone else says. And I'm telling you here and now that any provision that does not have a limiting feature of non-renewable, so many terms, over 2 terms, not more than this, a maximum period of this, any provision without that quality, which quality is found in all of the sections that the judgment courts except Section 95.2, anything that doesn't have that quality of being specific, in other words, Any provision which has no disqualifier is not a term limit provision. And I'm giving you that as an instrument to apply when you are reading any provision. I'm giving it to you for free. If you find a provision relating to a period, a duration, or time, but within that provision there is no disqualifier, you are not reading or looking at a term limit provision. And this will not change today in this because of this conversation. It will not change tomorrow. And that's what analytical rigor requires. All analysis must distinguish some provision or something. All analysis. If you say human beings are animals, you have to distinguish them from other animals by saying they are rational. The rationality becomes the disqualifier. But otherwise, a dog is an animal, a donkey is an animal, but it is not rational, and therefore it is not a human being. A term limit provision is a provision with a specific beginning and a determinable end, distinguished by its disqualifier. The differential of a term limit provision from any other provision of the Constitution is that it has a limiter, and that limiter is a disqualifier. Section 95, subsection 2B, section 143, subsection 1 do not have a limiter. They do not have a disqualifier. If you want a disqualifier regarding MPs, you will find it in sections 120, 121, 125, and 129. There are disqualifiers there. Those disqualifiers which are there don't include term limit. They are completely different, such that a person, if they don't fall foul to the disqualifiers that are specified in those sections, can serve as an MP for life. The president, in spite of not having a disqualifier or a limiter, which is similar, and I invite the neutral minds here. We are not looking for English and grammar, but we are looking for common sense and rationality. To read the judgment, and in particular, the so-called key paragraph on pages 50 and 51 of that judgment regarding what the inclusion of section 95. Look at that section 95, read it, and read the rest of the sections that are cited, and take note that the language uses myriad, many other things which are not put in, many other provisions which are not put in that judgment. Therefore, if it was so tying and binding and is part of the Mpungu precedent, why did the judge not include all of them? Because the Constitution does not have a limitless number of term limit provisions. If the judge wanted it to be taken seriously as now shutting the door on what a term limit is, surely he would have included all of the term limit provisions. And if he did not want to be misunderstood, why did he leave out section 91 subsection 2, which is the disqualifier? That's the only provision in the Constitution that disqualifies a president from serving for more than 2 terms. You know, so I have a plea. We've been down this road. Let us learn not to behave like we are in 2000 when we are in 2026. You know, and no one should advertise their profession and think they are making their CV big by telling us that they are lawyers. Political science are students of institutions of government. Political science is about institutions of government. And one of the most important aspects about institutions of government is how long they last as institutions. Are they perpetual? And there's no institution of government which is perpetual without demarcations for periods. When we say parliament, we don't mean a perpetual parliament. We mean a specific parliament since 1980, and we call them by their 5-year numbers. The first was from 1980 to 1985. The 10th is from 2023 to 2028, subject to amendments. Of course, it may go to 2030. But when we say parliament, we don't mean a perpetual, unlimited, boundless parliament. We mean a specific parliament. Then, therefore, there must be a law which deals with that perpetuity and puts it in a framework that is defined by election cycles. So that why do we go for elections every 5 years? Is because our election cycle in terms of section 95, subsection 2B, and section 143, subsection 1, and section 158, subsection 1, says we must go for elections every 5 years. Why do we want to understand the motivation for the change from 5 years to 7 years? Because the 5 years is too short, has proven to be too short. Besides being too short, it has become too dangerous in our scheme of politics due to the conflict, toxicity arising from the contest for one office. Contesting for one office when the Constitution in section 3(2)(a) says you must have a party political system, and a party political system does not dovetail neatly with an executive direct elected president. And having the president elected by parliament does not mean then the president is not an executive president. It's a hybrid system. The South African president is an executive president, and there are 4 in the Commonwealth who are in the same situation, and it's a creative system. Ours would even be better than theirs because we have a hybrid electoral system which has worked very well and which is the envy of the region, and which would be much more in line with section 3(2)(a) than the current system. Therefore, Mr. Ndebele, the answer to your question is that it is very difficult and poisonous in a political or constitutional environment where the electoral cycle is very short, and then you have a perpetual election mode where people are at each straw every day, and where policy making is paralyzed and worse policy implementation. Those who keep fighting for the direct election and wanting to talk about legitimacy as a result of the outcome of the election, not as a result of the implementation of the law, make sure that as part of their election strategy, they want policy implementation to fail. And that's why they use this ridiculous argument. Yesterday you said this is an unelectable president. You can't today say you welcome his proposal. I can if I'm rational. But it's difficult to be that in an environment where opposing for the sake of opposition is weaponized, and it becomes part of the tool that is used in between elections. The Sabbath proposition of 7 years disrupts that, Ndebele. It creates an opportunity for people who want every day to be an election to be prepared for the long haul and experience elsewhere. Ireland had 7 years. Guinea just did that in September. Other countries, China has more than 7 years. The African situation is unique for 7 years because whereas in 5 years, you just end up getting 3 or so years before even you, if you are the incumbent, start thinking about the election. Like right now, some people have started coming back when they decided they were on leave because they want the election to be in 2028. And so the next 24 months, we are supposed to see spanners being thrown and into policy making to make things fail and so forth. But if you have 7 years, you can't do that for 5 years. At least the government will have 5 years to implement real policy and to attend to what is really the problem for people. We don't live for election systems. Election systems must exist for us as people, and those election cycles are necessary if they are substantive, so that things like disease, things like hunger, things like poverty, things like infrastructure development cannot be derailed by unforeseen developments, such as a few years ago, the COVID-19 pandemic. For those countries which have multi-layered institutions and are effective for long-term policy making, long-term planning. I mean, you can think what you want about Vision 2030, but the fact is it was adopted in 2018, but it could not be implemented properly with the January 2019 staff, July 2020 staff, but more particularly and seriously with the 2.5 or so years COVID and so forth. We can only defer to them and hear from them, but we really don't know what the motivation was for ZANU-PF to make that resolution number 1, the members that is. But their case about the lost years in this phase of the election is compelling. Their solution is another thing, and I'm particularly pleased myself that the bill has not fallen prey to that resolution, has interpreted the challenge, which is not only unique to Zimbabwe. Many countries are debating these short-term election cycles, and Zimbabwe might produce a solution that will be a learning example for the other countries. And because the bill, and I'm really very disappointed that we come here and we insult the Minister of Justice as if we think he's the one who has drafted this, or even make ridiculous claims. I've seen some stupid claims that I did this and so forth. No, how can on one day I'm not a lawyer and the next day I'm drafting something as important as a constitutional bill? But I understand that is meant as an insult to the AG's office. That AG's office, the AG, the Attorney General, is not the one officer who holds the title. The Attorney General has very experienced lawyers who trained like you. If you respect lawyers and you are serious about describing government business, for goodness sake, take a big breath and understand that the Attorney General is the boss. She is the current one, the boss of many departments, including the legal drafting department, which has trained lawyers. It is a propaganda and an insult to other people to then mischaracterize that, scandalize that, and start coming here and telling us that, oh, this minister didn't even practice. So what? Oh, the AG, how can the AG put that without that? So you want to be the AG. She is the AG, and she put the term limit template as the Attorney General of the country, and she is a practiced lawyer. She has many years of experience as a prosecutor and so forth and so on. So I really want to end by pleading, Zenzele, Upolo, that if you allow these things where you bring these dramatists here, whose job is, who think they can do a hatchet job by running away from the substance, deflecting, to talk about us, because we will not talk about them as individuals, and mischaracterize, insult, and at the end of the day, leave your audience none the wiser about exactly, if I'm on my own, how will I then identify this Section 95 subsection 2 or Section 143 subsection 1 as a term limit provision or a non-term limit provision. When they've had a chance to listen to a high-flying lawyer, but they are left none the wiser. I think that's regrettable. We are capable of having a meaningful conversation, especially when it comes to these constitution-making opportunities. It is not a mean fact that, unlike you, we have spent days, weeks, months, and years seized with constitution-making issues in Zimbabwe for 26 years. It's not a mean thing. You can be as dramatic as you want and dismiss it, but you do so at your peril, because tomorrow will come, and when tomorrow comes, there will be promulgation of this bill, and you will have squandered an opportunity to input as a serious person, but you decided to use anecdotes. You decided to speak to the gallery. You decided to lie and present your being a lawyer as the best thing that happened since sliced bread. And the only most important thing, yes, everybody can vote, but lawyers must be voted. No. We can involve lawyers when we are drafting, but lawyers don't lead the process. Ordinary human beings lead the process, and there's a reason why meaningful citizens in their localities have elected their MPs. And you will not besmirch those members of parliament by using anecdotes and insults and hoping to achieve a result. There will be no result. The result will come from those who are making substantive contributions to the bill. Already, a number of women's groups have raised what, in my humble opinion, are legitimate questions about the termination, the organizational termination of the Gender Commission and subsuming its functions under the Human Rights Commission. I think that given everything else we have been exposed to and we know about the challenges that women face, it would be premature to do away with a specialized commission that deals with their affairs. And because the women are making their input meaningfully, and because they are not using it as an invitation to start insulting each other or insult other people, they are likely to get their way. I pray that they do. Thank you, Zenzel.
Well, thank you, Professor Moyo.
Thank you,
Well, thank you so much, Prof, for responding. Well, guys, this is a debate, and Professor Moyo has given his response and also responded to Zenzele's question. I'll now give back the mic to Dr. Justice Mavedzenge to also respond to Professor Moyo. And my question:
excuse me, Nonhlanhla. Excuse me.
Yes, Prof.
I will want also to respond because I was responding to what he said. Why should he respond to what I'm saying? You want us to spend the day responding to each other? That is ridiculous. Because make no mistake, I'm ready and willing to respond to him. If he wants us to play a name-calling game based on anecdotes, let him be my guest. But I have to warn you. If you are going to proceed by saying you respond to this, you respond to this, then I'm afraid, I'm not aware. Even cross-examination is not done like that. When I made my presentation initially, I never spoke about him. I focused on the issues. I gave you what I think is the foundational question that is prompting this bill. I gave you my considered view of what I think are the operational assumptions that are guiding it. And I dealt with the questions of what a term limit provision is and what it isn't. I did not even mention anything about the court. I didn't think, and I still don't think it's relevant to this. This is not going to depend on what the Constitutional Court said. In the end, on some day, the questions of what is a term limit provision as it relates to this particular issue will have to be settled by the same court. It is accepted. And
All
this
right.
lie that, that court might clamp down because we are saying A, B, C, D, as if they are not saying X, Y, Z. It's outrageous. It is outrageous.
Prof.
Now, you nonsense, if you want us, because now you are saying, opportunity to respond. Respond to what when I was responding to him?
Please, Jonathan, this is not ZBC.
No, don't be ridiculous. This is not a NCA either. Don't be crazy. You think that we are afraid of you. Who the hell do you think you are?
Babum Lev.
No,
Yeah,
I mean, this guy is outrageous,
Yeah, but
it takes two to tango. We cannot allow to be abused by outrageous people who are not putting anything serious on the table. Nothing
Prof,
like that. And making insinuations. Hey, student, no, justice forget it. Just forget it. I actually listened to you, but I just find it ridiculous that the moderators, after you took the opportunity and used the bulk of your time insulting people who are not here to respond for themselves, engaging in mockery and pretending that your mockery is commentary. We are not born yesterday. We are not the first academic that we are experiencing. But if you think we will allow you to come here and use the opportunity to abuse because you and your network thought, and I'm monetized also. You are just playing. We are just playing because that will not happen. And I'm saying, Baba Zenzel, this guy, you gave him an opportunity and you didn't stop him. He used that opportunity to talk about Jonathan Moyo. He didn't use the opportunity to talk about the amendments. And when he was making some references to the amendments, he continued to make personal attacks, which were so self-evident. He continued to do that. I want you to contrast, and I have my verbatim record. I want you to contrast my presentation and his original presentation in relation to the question of the day. He was all over the place, wanting to tell us about military coups and so forth. We know, my friend, when we propose amending the Constitution in relation to
can we try and now bring it? I know you've raised these issues, and the round two was supposed to be you answering the question and Justice answering the question, we give the public to answer
round
the question.
Two.
So we stick to that so that we get to a logical conclusion.
What Nonsense is saying is not sticking to that, my friend. The guy decided to make his presentation a personal attack and saying he doesn't understand why someone who was doing this yesterday is doing this today. How does that speak to the bill? Why can't he say, I don't understand this point you are saying about the bill? Is it his business? Am I supposed to, is it his business to talk about how I make my opinions? Am I not entitled to make my opinions? Now, when you allow a person like that, you should allow the other person to respond, which I've just done. But for you to give him another opportunity to say, hey, speak, I'm sorry, guys. This guy is a lawyer. He knows how cross-examination is done, And if he thinks now he has a second chance to insult, no. And I can assure you, after he does that, you should give me an opportunity. And I'm going to deal with this. When people decide to speak in a certain language, approach an issue in a particular way, they should not be foolish to think they have a monopoly. No. It takes two to tango. So I'm not going anywhere. I'm actually ready. You can give him the opportunity, but you should also give me back the opportunity, because that now is changing the terms of reference. The terms of reference, as I understood them, he speaks, I speak, he speaks, and if he says anything about me, I will also have to respond to that. If he doesn't say, we will let it go to the general participants and, allow them to ask questions, make their comments. But if you want it to be between me and him, I'm ready. But I'm not going to allow some funny guy with an exaggerated sense of his profession to start saying nonsense.
Prof.
Yes.
I think, hold on there. We ask Justice a question. If you need another opportunity, you can have it. We can be here the whole day so that we ask. So the question that we wanted to ask Justice was, he talked about the constitutional amendment and the issue of a referendum. And since this process, in terms of justice, what do you think is the role of the citizen? And if ever they wanted to push for a referendum, what are the options?
Thanks, Zenzele. Thanks, Nonhlanhla. Let me respond to that in the context of an hour-long response that we got from Professor Jonathan Moyo. There are some things that he has raised, which, in the spirit of debate, requires to be responded to. So the first issue, or rather claim he made, is that the language of a constitutional coup is my propaganda. The simple answer to that is no. It's not my language. It's not my propaganda. That is the language of the African Union, which arises specifically from Article 23 of the African Charter on Democracy, Elections and Governance, where the Charter says changing the constitutional term limits without following due process or through undemocratic means.
This is what I really don't. No. Let's take issue by issue. Because already you are misrepresenting. You are saying that the language of constitutional coup is...
Are you not going to get an opportunity to respond?
Yeah, but Zenzele, let's prepare.
But you said you are going to respond.
No, except
you said you asked for an opportunity to respond, and I agree.
Okay, that's fine. I think you have a point there. But Zenzele...
So can you just allow me to...
But I want...
Can you just allow me to...
I'm drawing a point of order to the moderators. Moderators, since he's raising a question about this language of
Jonathan,
I'm not talking to you.
Can you?
Zenzele,
can you? No, you are inventing.
Can we go issue by issue? Let him make this
You
point.
are being a disruptor right now.
No.
You are being a disruptor right now because I'm making my presentation. You asked for an opportunity to respond, and we agree.
Justice, may you please both hold on a bit?
Yeah, but I have a request to you guys.
Prof,
when he raises an issue, can we go issue by issue?
Prof?
Yes.
Yes. Let's allow him to respond to my question.
Yeah, no, but I just want I want a clarification of a rule. Indeed, let him respond. But can we, for the sake of progress, when he makes a point such as the one he's making, can I then respond immediately after, before he makes... Because this is a different round now. You can't allow him another response. So it's okay for him to say whatever he wants, but don't allow him in this round to make one point, another point without a response. Because I would like to respond to this question immediately after he speaks and speak concisely on that point, and then we move on to the next point. I'm requesting that as a rule. Otherwise, if you allow him to speak, and because already he is misrepresented, and it will be so difficult to have a litany of misrepresentations. I just want, we can't speak as we did initially. Can we be systematic? Yes, let him speak. I have no problem with that. But can you allow me to respond after one point, please?
Zenzele, I could have made the same request when he was responding to my presentation. I did not, because I respect him. I respect the audience. Listen, I don't think we are engaged in a contest where we want to I mean, for our own purposes. We are engaging in a contest which should allow the people who are following this conversation to draw their own inferences, to draw their own interpretations. If I am the one who is being ridiculous to attack the person of Professor Jonathan Moyo, let the people draw that inference on their own. Why are we so eager to control the way people think? So I will make my response, right? I never interrupted him. I will make my response, and he is free to make his response.
No, I have no problem with that.
And I think, Zenzele, I think this. Why is he so afraid of giving?
There is no fear here. I actually want to take you on full force on each of your allegation, one allegation at a time. I mean, it makes sense,
Prof. And Dr.
You make a point, and the point is responded to. Why are you afraid of having a response to your point immediately after making it?
I can answer. Because you speak for 1 hour to respond to one point.
No,
and we have no time to be here.
The rule is changing. No, I mean, let them. It's very easy. It's very easy to make a short response to a comment that's made. Even in court, no one is allowed in cases like this to just ramble on and on without rules. The reason I took all that time is because your original presentation was substantially about personal attacks, and they needed to be responded to. And my presentation was not, did not contain a single personal attack. So having learned your approach, it would help everyone concerned. You make your point and it gets responded. This is the new, even me, I stop from saying other things. I just concentrate on that point. The rule should apply to both of us.
Prof, may I request that we let Dr. Justice speak and then you will come in and speak?
No, but I have a problem being given another litany of issues. And the person is saying all those things. And the nature of responding after someone has given a litany of issues is that time becomes a problem. And that indeed a lot comes into. And I don't know what you and him are afraid of, to let him make a point. I clarify the point if there is a need to clarify. And he proceeds. And I don't say anything else, but I just address the specific point. You know, why are you afraid of that? Why do you want to give him to continue? And you are saying he must continue just because I responded. And yes, he said, everything he said was just, as I've been saying, a litany of insults of people here, of me, and of people he thinks moved the or drafted the bill, but who are not here to respond to him. So, for the sake of progress, non-answer, I'm saying let him make a point and make it whatever he wants to say. No problem with that. But rather than allowing for this round the same issue as we did the last round, let's go point by point. And if we've exhausted the points, or if you want to limit, you can even limit us on the number, because this is a different round. And really, there is a lot of harm having someone who keeps talking without being responded to, and is making just a litany of outrageous points. And the public will understand well if both of us deal with the same point. Not that I now must choose which points and so forth 30 minutes later. I'm prepared to be here for the whole day, but now for us to be informative and helpful to the audience, let's go point by point. I make a point, he responds. He makes a point, I respond, and we'll continue like that.
Notala, we cannot be held at ransom by one person. I will continue to make my presentation. If he wants to interject, he is free to do so. I will ignore his interjections. Let's continue.
Yeah, but
Jonathan Moyo has made a point about
a
constitutional coup, and he says the language of a constitutional coup is my language. It is not my language. That language arises from Article 23 of the African Charter on Democracy, Elections, and Governance. Right. The second point that he made is that today he says Zimbabweans today have a choice to decide in favor of the bill or not to. That is not true. Zimbabweans are not being given a choice to make. If the country was being given a choice, then the government would follow the constitution to give Zimbabweans an opportunity to make a choice through a national referendum as is required under the constitution. You cannot honestly say as a cabinet, we are asking parliament to decide on behalf of the people whether the term of office for the president should be extended and whether the current president should continue in office beyond his term limit. But at the same time, we are also saying members of parliament benefit from the same proposal. So the members of parliament are conflicted because they benefit from the same proposal. There is no chance under the sun that they will vote against this bill. But that's besides the point. The central point is it is simply not true that Zimbabweans have a choice today. They don't. And that's exactly why we are having this debate. I am fighting for Zimbabweans to be given a choice. Jonathan Moyo is fighting for Zimbabweans not to be given a choice to make a decision. That's what this is about. The next other point that Jonathan raises is that he says we are not prisoners of what other people write. And he says this in reference to the decision of the court in Max Mupungu versus Robert Mugabe, particularly, Max Mupungu versus Minister of Justice, particularly where the court says Section 95 is a term limit provision. He says we are not prisoners of what other people write. First, this is a judgment of the highest court on constitutional matters. It is not a newspaper article. It is not some article that other people have written. We are bound by it. If the use of the term prisoners is meant to show that we are bound, yes, we are. We are bound by what the constitution, the constitutional court says, because that is what the rule of law says. That is what the rule of law says. We are bound by what the court says. And it is important that when a court outlines a position, as it did, it is important that that position is maintained, because rule of law, by its nature, is based on the principle that there must be certainty. But if the Constitutional Court makes one decision today and makes another tomorrow that is opposed to what they have made before, then that shows total disrespect for the rule of law. But it's also total disrespect for the rule of law to describe judgments that are written by judges as the things that we cannot be prisoners of because other people have written that. No, that's wrong. Then he alleges that I have not dealt with the substantive argument. Yet, I think he spends a lot of time talking about why Section 95, in his view, is not a term limit provision. And then he tries to respond to a question that I asked. The question I asked is, why do we hold elections every 5 years? We hold elections every 5 years because Section 95 2B of the Constitution says the term of office for the president is limited to 5 years. And when the 5 years expire, we go for an election. Right. But his response is, no, Justice, we hold elections because we have always held them that way since 1980. I mean, We are supposed to be a constitutional democracy, so we hold elections in terms of the Constitution, in terms of the rules that are laid down in the Constitution. And the rules are there in Section 95, subsection 2. Now, you cannot, and this is the point, you cannot extend the term of office or the period of being in office for the president from 5 to 7 years without holding a referendum, as is required under Section 3287 of the Constitution. And that's not my mere propaganda or my position as a person. That position is backed by two judgments that I cited. If you have problems with Max Mupungu versus Minister of Justice, then you have another problem that you have to deal with, because there's a jealous Mawarire versus Robert Mugabe judgment, which says the term of office for the president is limited to 5 years. Now, finally, on changing positions, and I think this is where a lot of heckling has gone around. I am not criticizing Professor Moyo for changing his positions, but because it is acceptable to change positions. It is acceptable to change positions. But when a person changes their positions regardless of principles, that person naturally faces a credibility crisis. And that is the crisis I was flagging, because he had invited us to trust that this bill is meant to deal with electoral toxicity. But what he is saying is at tangent with what he has written, including in this publication of 2018, Excelgate. That's the point I made. And I'm not sure how that is a personal attack. It's a critique which is based on what he has written. And I'm saying his current position is not supported by what is not in sync with what he has said before, right? And he faces a credibility crisis because of that. Over to you.
Well, thank you so much, Dr. Justice, for responding. And now I'll give Professor Moyo a chance to also respond. And Prof, for this one, I'm giving you 3 minutes to respond.
No. You are giving me an opportunity to respond to the 7 questions that you said. Yes, I will be focused on them. I won't say anything outside them. But you can't start telling me you didn't give him a particular time to respond to me. So why are you giving me a particular time to respond to him? I have to respond to the 7 questions that he has raised. And I think that is only fair. So I respond to the first question. He says that it's not him who is alleging that there's a constitutional coup, but it's Article 23, blah, 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 blah. And he is wrong. There is no UN, AU, SADC, or any specialized organization that has said what he is saying, namely that this is a constitutional coup. It's one thing to define what a constitutional coup is in reference to authorities, and quite another thing to take that definition from whatever authority and apply it to a particular situation and reach a conclusion that you have not demonstrated. A student who does that ought to fail. Yes, we know that there is a concept of a constitutional coup. It is not your creation, but you are misapplying that concept. And you, not anyone else, you did not quote anyone else drawing the conclusion you are doing. You are entitled to draw that conclusion, but you should do so with demonstrable evidence that this amendment constitutes a constitutional coup for X, Y, Z, which you have not done. Then you are saying you are playing God as one who is fighting for Zimbabweans to be given a choice, and you are alleging that I'm fighting for Zimbabweans not to get a choice. What kind of a Democrat are you? You want to have your own debate alone with your echo chamber and repeat your propaganda that you are fighters for other people. No one has elected you to fight for them. It's a choice and a claim you are making, and you have not proven that your claim is grounded in any empirical reality. I would listen to such a claim if it were coming from a member of parliament. But coming from you, it is a baseless claim, and you have not made a case for it. And the fact that you are declaring it doesn't make it factual. Number 3, you say, what law says members of parliament, or no, rather, you are dismissing parliament, disqualifying parliament. But you are making it appear, you are saying there must be a referendum. There should not be a referendum because you say so. There should be a referendum because the Constitution says so. The Constitution is clear about which cases require a referendum. You have not demonstrated, besides making sweeping claims, not supporting them, that a particular section of the Constitution, I suppose Section 328, actually says there must be a referendum. And you are making this as a claim prematurely. The legal making exercise in Parliament only started on Tuesday with the counting of the 90 days during which you, me, and other people should engage in debate and so forth, and then Parliament will be seized. But even before MPs start their work, you are pre-empting that exercise. You are reaching pre-analytical arguments. You are making arguments to cast aspersions. The process is illegal. Who said the process is illegal? What is it that has been done right now in relation to this bill, which is not following the Constitution? Is it wrong for a cabinet to come up with a bill? Is it wrong, violating any particular law, for cabinet to give that bill to the Speaker of the National Assembly to gazette it? Has the Speaker of the National Assembly not gazetted the bill? You are just making poisonous arguments, unfounded, unsupported by empirical evidence, unsupported by any law. They should be taken by the public as authoritative because you, some lawyer, is saying it. And that is not a basis of rational, conversation. Self-appointed authorities and everyone else is wrong except you. And when you are pointing it out, you don't have to use evidence. You don't have to cite the law which you claim is making these requirements. And 4, you say that, which is, I think, I mixed number 2 with number 4. So I have answered number 4, where you say Zimbabwe, you want to give Zimbabweans a choice, and you claim that I'm fighting for Zimbabweans not to have a choice. You are judge, speakers, prosecution, police, and jury. I think you should learn to restrain yourself. I want to repeat. Just take a look at the presentation I gave at the beginning of this. It was on issues, and I was, as I still am, ready to engage you on issues. This judgmental toxicity is just crazy, because you're simply nobody to pronounce judgments on other people. I answered that.
And who are you, by the way?
Number 2,
and who are you, by the way?
Are given. Me, I'm Jonathan Moyo, and I'm making my own argument. I'm not making an argument on behalf of anyone else, and I'm entitled. And I did not make a judgment in my presentation on anyone. I made a judgment and an analysis of the issues. And I think on any day, that's much better than going after anyone sitting and pontificating in judgment of their characters and so forth. But the question, so I've answered 4. The question I didn't answer under number 2 had to deal with you clarifying what you meant about the question, why do Zimbabweans go every day? I mean, every 5 years to elect, and then you continue not to ground that in relatable empirical wisdom, because the fact of the matter is, I didn't say that we go for elections every 5 years because we've been doing so since 1980. You did not understand, or you chose not to understand as usual, to deflect in order to create your drama. I said we have been doing it since 1980 in terms of Section 29 of the Constitution, the former Constitution, from the time when we had a titular president, all the way until 2013 in terms of that section as amended along the way, first in 1990, second in 2007, and in 2013, the same section was retained. And I'm telling you that the section which has to do with us going to the elections remains the same since 1980. And I'm telling you that in that period, it never ever operated as a term limit provision. And that you and your ilk are declaring it and calling it a term limit provision for the first time now, because you are playing politics. There is no law that you are playing there. You are using your clothes to mislead people, and that's why I say you are doing propaganda. You are not doing legal analysis. You are not even doing a review of how and on what basis the Zimbabweans have gone for elections every 5 years since 1980. They have done so because there's a law which describes an election cycle which starts at a given time as per the Constitution, and it does so through a general election, and it ends upon the dissolution of parliament, whether sooner than the prescribed time or at the automatic dissolution of the prescribed time. And when that happens, we have the timing of elections in terms of Section 158, subsection 1. And that has nothing to do with a term limit. We have had it and we've been doing it since 1980. And when we adopted a new constitution in 2013, we did not change the substance and form of that. We continued it, but decided in relation to the president, not members of parliament, but president, to come up with a term limit provision. And a term limit provision is a disqualifier. It's a disqualifying provision, whether it's in the US Constitution in terms of their 22nd Amendment, or South Africa, or Botswana. It's a disqualifier. We did not have a disqualifier for the president, and in fact, for most of the public offices from 1980 to 2013. We introduced the disqualifiers in 2013, and they are 15 in number. They are exhaustive. This constitution begins and ends. Within it, it presents 15 term limit provisions, and one major defining characteristic of each one of them is that they are disqualifiers. All of them, there is none. And that's why the inclusion of Section 95 among those 6 or so, which was not exhaustive, it's just a few, and using the word like myriad, which is not a legal guiding term, that's why that inclusion is wrong. So don't mispresent me, especially when I'm still here listening to you, and say that I simply said we go to elections every 5 years because we've been doing so for since 1980, and you keep quiet. When you are doing that in academia, it's called dishonesty. You are misrepresenting a person. When I made it clear that there has been Section 29 since 1980 up to 2013, and that Section 29 became Section 95, subsection 2B in 2013, and its form and substance did not change. Nothing was done to it to reconfigure it to constitute a term limit by putting a disqualifier or a limit or a cap. It simply defines the election cycle so that we continue doing what we've been doing, namely every 5 years, go and vote for the president and parliament, because the life of the presidency and the life of parliament as institutions are intertwined, they are linked, they are coterminous. That's the reason. 6, or rather 5.
No. Can we please give others an opportunity to speak? No, this is exactly why I was refusing.
But you said 7 things.
And
this is exactly why
I was Jonathan, you can't monopolize the debate. There are 1,100 people on this space who want to speak.
You see,
give others an opportunity to
this
speak.
Is what... you see, this guy is afraid of being exposed. He doesn't want his nonsense to be responded to. He's running away. And you guys, the moderators,
you are out of order.
I told you that you allow him to speak and I respond to each one.
Yeah, but
I have responded. I've responded.
You want to speak for an hour?
You make your bed. You must lie on my bed, my friend. You think that because of you are a lawyer who is engaging in propaganda and not legal education, you must not be responded to. But you are a complete liar. You are reckless with facts. You misrepresent a person.
Point of order, Zenzele, point of order. I do think, out of the respect for the 1,100 people who are here, who came because they also want to ask questions, I think Professor should be... Professor should be ended now. He has made his point. Otherwise, this is no longer a debate. It's a monologue.
Dr. Mavedzenge, may please hold on a bit.
Nonsense. No, I will hold on just now. I've answered 5 of his 7 questions. I told you, can you allow him to speak and you allow me to respond? Precisely because I was concerned that because he is engaging in propaganda, he will raise a number of questions and not want all of them answered. Because when you answer all of the questions at once, you seem to be taking a lot of time, which would not happen if you are answering question per question in this phase. So he raised a lot of things, misrepresenting, lying. He doesn't want to be responded. I want to respond. I've responded to the majority of them, and I'm just remaining with 2. And why was I stopped when I'm remaining with the 2?
All right, Prof. Dr. Mavedzenge, may I request that, Prof, you finish responding to the last questions that you have. But my request is, if you can try and, take a bit of less time, because of time, we've been here all morning, and being a school day, I also need to go for a school run. Zenzele needs to go for a school run.
Yeah.
So
me too.
And hopefully we were hoping that people can also ask questions. So I'll at least give 2 people to ask questions. So guys, if you have questions, please drop them in the comment section, and I'll pick one for Professor Moyo and one for Dr. Mavedzenge. So Prof, please do go ahead and answer the remaining 2 questions. Yeah, but hopefully let's try and minimize the time so that we are able to go and pick up the kids at school as well.
Sure, I understand that, but you should have stopped them from asking all these questions. 2 questions now that are remaining. One, he says that the orbiter, we don't know whether he even considers that it's orbiter, but he says the section in the Mupungu judgment which deals with the inclusion of Section 95, it claims that I scandalized the court by saying we don't want to be imprisoned by what anyone writes. I repeat, we don't. And we have a right as citizens to go back to the same court to tell it that it misguided itself in reaching a wrong conclusion, which some other people out there are abusing and misinterpreting, and they are doing so by using their jackets, like judging a book by its cover. Just because a book has a certain title, just because a person has a certain job, what they say is accurate, and we should all sit down which is actually very nonsensical. It is not wrong for a citizen to say the court has misdirected itself and to say its inclusion of a particular thing is dangerous because in the hands of reckless people, it will cause a problem in society. And the recourse is to the courts. The recourse is not to you, Justice. The recourse is to the court, not to you or your friends. The court is accessible to everyone in terms of Section 69. And everyone will exercise their rights as they deem fit. It's none of your business. You are entitled to your opinion, but you are not entitled to your own law, and you are not entitled to your own facts as far as that is concerned. The last question, non-answer. He said he's talking about me personally because now is raising what he alleges are questions of principle, that how come what I criticize as toxic before, I now embrace this? Quite frankly, you have to be unthinking to see that as a conflict. I need a change for those things that I talked about. That change cannot happen with this system of election. I'm arguing for a different system of electing a president, partly because of what I observed during that and period when I published what you say you are reading and enjoying. But that's not the only experience. Most rational people agree that and I know a number of my colleagues from the UZ days, we didn't support the adoption of the executive president in 1987. We saw it creating unnecessary structural problems. And we said so then. We also repeated that in 2000 during the constitution making exercise. That's why we proposed the establishment of an executive, a prime minister who is drawn from parliament to be the head of government. That was a direct attempt to kind of reform and address the question of the structural disjuncture that was caused by the adoption of Amendment number 7. It is common cause, and it is not a bad thing to say because it opens our minds to try and be focused to solve it. That executive presidency was adopted in that time, anticipating the establishment of a one-party state in Zimbabwe. But it is also a common cause that we didn't establish it. And when we had an opportunity to revamp the constitution in 2013, the ZANU-PF and the MDC formations agreed in keeping that thing lock, stock, and barrel, just as it was, while they were changing everything else. There is a conflict when that happens. We can enhance our democracy, not necessarily by going back to have a prime minister, but by continuing the executive presidency in a different way, where the vote is not subject to, or does not subject to the dynamics we've seen, and does not breed the divisions, polarization that we have seen. I can't imagine. I find it deplorable that an academic says, but you complained about the executive presidency in 2018. Now you are doing this. That would be true if we are sitting here with me arguing for the retention of the executive presidency. I'm not. I'm here arguing in support of the proposed amendments in the bill. They will solve those problems. There will be no need to write Excelgate when the president is directly elected by parliament. We will less likely see the political violence that we have seen. We will come closer to the best practices among our neighbors like Botswana and South Africa, but we will also be aligned with progressive practices among the majority of countries that are in the Commonwealth, those that are using the Westminster system and those that have the direct election of the president, but are looking at reforming that to have a hybrid system. What is being proposed in the bill is a hybrid system. Now, for a person to deal with me personally on the basis of empirically false reasoning, that, oh, in 2018 you criticized this, now I am like, look, if your problem is President Mugabe in particular, so that if he says today is Thursday, I must challenge him and say, no, it can't be Thursday, you are not the right person, I can't start saying today must be Monday. That is outrageous. But if he comes today and does what he has done, as a responsible person, I should not personalize politics as if it's my mother's business. Politics is everybody's business. Politics is intergenerational. What has been proposed is wonderful for generations to come. It may not fix every dot or cross they might be, but foundationally speaking, it is definitely much better than what we have and much better than what we have had. And it is sheer lunacy to say, but you are contradicting yourself, because I'm not. I'm actually in sync with myself. Thank you.
Well, thank you so much, Prof. Unfortunately, I'm failing to add speakers. I'm seeing your request. I'm trying to add you guys, but I'm failing. So for now, I'll take the questions in the comment section, and the ones that I'm seeing right now are only for Professor Moyo. So, Prof, there's a question that says, if extending the term to 7 years is for reducing toxicity in our politics, what happens if after 7 years there's still toxicity? And the other one says, how can we identify and protect against agendas taking advantage of this technicality?
Yeah. First of all, I thank you for that question. Actually, the amendment bill does not extend anything. It lengthens the duration or period of election cycles in Zimbabwe. That's not an extension. Because people want to say an extension for 2 years, but there's no extension for 2 years. There's a redefinition of the recalibration of the election cycle. Currently, Zimbabwe's election cycle is 5 years. The amendment shifts the 5 years to 7 years. There's no extension there. There's a change. There was earlier talk about extension, and rational people debate. I've seen some colleagues saying in 2024 October, when Comrade Chinamasa was presenting, he said there should be 2 referendums. Yes, he said that. But he said that because at the time, the talk was that the term limits will be removed. They will be removed, and so there will be an amendment of section 91(2) and section 3287. And this was said openly, and no one was hiding. And if that had been done, and that was the only thing to be done, then you would have needed 2 referendums. But there is no amendment of section 3287, no amendment of section 9912, no amendment of any term limit provision. There is a lengthening, not an extension, a lengthening of the election cycle to shift from a 5-year election cycle to a 7-year election cycle. So this is the thing. But you ask an important question, which says, okay, extension or a lengthening, same difference. What happens if the toxicity still remains? Usually, you can't legislate for the future. We're legislating for now. That's why the future parliaments are free to deal with whatever encounters them. But usually, when you make such amendments, there have to be other supporting amendments which are there, some, but some which are consequential amendments that will be in different acts, such as the Electoral Act and so forth and so on. This is not a one-day fix everything. This is a one-day reconceptualizes a serious problem that has burdened us since 1987. And the fact that we have a leadership that has dealt with an institutional question beyond its own time context that is supposed to outlive the current leadership is a new in Zimbabwe. Previously, we just saw tinkering that was temporal and contemporary. It was not future-oriented. There are some people who want to use the direct election of the president as a weapon for pursuing nefarious agendas like regime change. Some people who think that the direct election is great for election observer mission reports and so forth, and who think that when Parliament does that, it would be such a straightforward thing and will not bring the chaos that the other system has done. And those people, in defense of self-interest, but always presented as defense of the Constitution and so forth, they are going to keep the executive president. Among some of them, in the manner of what my brother Justice has been saying about me, they are actually contradicting themselves. They've published a lot of things since 1987, some of them with my colleagues at the university, against the executive presidency and arguing for a prime minister. Even the NCA constitution in 2001, it is a prime minister, not an executive president. It is a ceremonial president. But today, because they think, no, this is the other guy, and there's an agenda here, they don't come clean, they use words like mutilation. The only mutilation of the Constitution I'm aware of in recent years was that decision by the High Court in Harare, where the parties consented before Justice Chiweshe on the constitutional interpretation of Section 212. And the constitutional interpretation they gave is outrageous, but also the process of having people arguing a constitutional issue and then going in chambers behind the scene and saying we are consenting. And some of one of the key parties to that case, President Mugabe, didn't even know that the case was going on. And on the 24th of November, 2017, when that case was heard, he had resigned on the 21st of November through Parliament. And how he was cited as president of Zimbabwe on the 24th, God knows. If those people were serious, they would have said, now that he has resigned, case has been overtaken by the events. It's no longer dead. But no, they went on to come up with something which defaced the reading of Section 212 as read with Section 2013 and 2014, and basically saying it is legal for the army to self-deploy. And now they are saying, and I saw even Justice saying this, Moyo is saying is getting revenge against the army, and that's why he's supporting this. No, I'm a political scientist. I know that a military coup can happen even when you have the best constitution written by God. But the idea that we have an interpretation to say that upholding the Constitution means self-deploying and not aligning to civilian authority is wrong. And as normal people, we should right that wrong. And it is mischievous to attribute personal motives in doing this. I know there are a lot of motives hunters out there, but it is mischievous and wrong and unfair that at every turn you try and shut out people by unpacking their characters, scavenging the past and bringing things from the past and using them as a response to current issues which are new and different. So I am hopeful, colleagues who asked this question, that the structural changes will trigger different behavior. Human beings behave according to the structural parameters under which they find themselves. And a different thing like this, in my view, is most likely to alleviate all, if not most, of the toxicity. I thank you.
Well, thank you so much, Prof. I see I've managed to add one speaker there, Tawana. Good afternoon. Do you have a question for Dr. Justice? Because we only had questions for Professor Moyo.
It wasn't a question, but it was just a brief contribution, a brief rebut to what Professor Jonathan Moyo I had said earlier on. So if you don't have time, okay, that's fine. I can give other people good time for questions.
Okay, maybe can I give you a minute to give your contribution, and then we give them a chance to close off, to give their closing points.
I think my contribution or my argument was relating to what Professor Jonathan Moyo said, the Sabbath proposition, which he had inter alia argued that its raison d'etre is to act as a panacea, a silver bullet, to address both the historical and the contemporary sectarian divisions, sectarian violence, toxicities, polarizations, and divisions which had plagued both in historical and contemporary Zimbabwe. The electoral and political body polity of Zimbabwe. That by removing direct presidential contestation, by proscribing Zimbabweans from directly electing a president, that will automatically and naturally resolve all these sectarian toxicities and polarization divisions within Zimbabwe. I think it's not based on historical and material fact. I think there's a bit of dishonesty in that. Because if we go back to the very foundation of the modern state of Zimbabwe, from 1980 to 1985, 1980 elections and 1985 elections, they were contested under the banner of Lancaster House Constitutional Conference, which gave us the Westminster parliamentary democracy, parliamentary representation. Back then, Zimbabweans didn't directly elect an executive president. But as most people know, it was that period in the history of Zimbabweans that people witnessed unprecedented ethnic, social, cultural divisions, genocidal violence, war crimes were perpetrated, crimes against humanity were perpetrated during that period. And in 1985, P.F. Zapu and Joshua Nkomo, they lost 20% of the constituencies they had won in 1980 elections. As a result of the genocidal terror, the violence, and the hatred which were perpetrated against them. So I don't think that by removing the executive presidential contestation, direct electing a president, all of a sudden, all these divisions, which are deeply entrenched in Zimbabwe, will be resolved. I think what is needed in Zimbabwe, rather than extra constitutional and extra legally butchering the constitution, what is needed, and what has been proposed as well by leaders such as President Thabo Mbeki, Jacob Zuma, is about institutional reforms, institutional and structural reforms. These are what are needed in Zimbabwe in terms of administration and managing of the elections.
All right, I'm not sure if I've lost you there, Tawana, but yeah, we had most of your submission there. Prof, let me give you 5 minutes to respond to Tawana and give your closing arguments, and then Dr. Justice, you also give your closing arguments.
Thank you, Nonsanta. I think that the point about which Tawana makes about the electoral experience between 1980 and 1990, in particular, when we had the election, although maybe 1980 and 1987, because Amendment number 7 came into effect in 1987, is indeed well taken, well made. I detailed that experience in Voting for Democracy, a book I did when I was at the UZ, which goes into great detail about that. But I would like to suggest to Tawana that actually neither my argument today here on this platform, but more importantly, nor the bill proposes to go back to the pre-1990 situation. There's no creation of a prime minister. It's a president. It's a hybrid, executive president, in fact, a hybrid arrangement, structural tweaking. So it's not correct that it's going back to there. It's correct that the situation was such as we described, and there's a keenness not to return to that situation. It's also not correct, either in the bill or in my presentation today, that the view is if you change or shift from direct election to indirect election, all the problems of toxicity, divisions, and so forth and so on will disappear. There's no position like that in the bill, and I certainly didn't argue that. And then when you say what is needed is an institutional and structural reform, and then you seem to point to the behavior of some people. Well, only God can reveal himself to us as human beings and tell us to behave better, or even transform us, send these angels. But human beings behave according to structures that in which they find themselves. So that's why social engineering is such an important thing. The amendment is in fact an institutional and structural reform. You may not like it for one reason or another, but please recognize it for what it is. It is seeking to change the system by which we elect the one office that has become the most important office, most consequential office in our lives over the years since 1987. It's to tweak it, and to tweak it guided by our own history and guided by our own electoral system, which is a hybrid system, and which, as far as systems go, is a fairly good system. And taking into account that since 1990, from 1990 to 2008, our hybrid system, which was formalized in the 2013 Constitution, has proven to work exceedingly well at the level of constituencies. Even electoral jurisprudence is proving to be one of the best in the region. It's settled. Yes, you can get an odd situation here and there, like the Chagud West in 2018. But the general point is that the conduct of elections in constituencies, wards in Zimbabwe is working very well thanks to the changes that were done in 2013. And what has remained unattended is the presidential side. And this is a robust and honest, in my view, approach to deal with it as a solution for the future, because it will only come into effect in 2030 when we have a general election, or if there's a vacancy in between now and then, should it be promulgated. But it is clearly and unquestionably an institutional and structural reform. We are not fixing, human beings. It's not about good guys versus bad guys. It's about what institutional and structural reforms will help to deal with the divisions we have seen, which are amplified by the direct election of the president. But to totally eliminate them will take a little bit more work. But we have empirical evidence that the elections that are conducted in South Africa and Botswana on the election of the president tend to be prone to these ills much less than elections that are a direct election of the president, like Mozambique 2 years ago, Tanzania last year, and our own experience. And that instead of putting our hands and sitting there akimbo, we ought to do something. One thing that one rallying call in the civil rights movement is do something. And when a national leadership does something, I think we do need a culture of encouraging, of embracing that there's something that is being done, especially when it is clear that it will benefit our coming generations down the line, to all things working properly. And for me, I know, as I conclude, that, and I mentioned this in my remarks, that they focus entirely on the amendment, that of course it is common cause that the debate and discussion was kick-started by that resolution number 1. But the substance of what we have is far much richer and is addressing wider problems. I think the creation of more seats in Senate, entirely based on technical competence and skills, is very good. And I know that other people are saying, oh no, but it blots parliament, or that, oh no, here's another patronage scheme. We are human beings, and we will continue to have imperfect republics, imperfect unions, but we should endeavor to make it more perfect, less imperfect. And we should recognize that we will not reinvent the wheel. The House of Lords in the United Kingdom has more than 800 members who are elected by the political leadership there, or appointed, as a matter of fact. The House of Lords itself is an unelected body, but it has quite a role to play in legislation. And the memo of this amendment says one of the things we might benefit as society from the increase of the seats in Parliament, in the Senate, is a pool for appointing ministers. We will not be the first to do that. When Rishi Sunak wanted to have the skills of David Cameron a few years ago, in 2021, I think. He appointed him foreign secretary, but he was not in parliament. And he made him a peer, a life peer in the House of Lords for him to qualify, because a member of the executive should also be in parliament. If they can did it, as the proverbial question goes, why can't we did it? And why does it become a scandal and everybody's drum when we align ourselves with best practices while keeping our own identity and so forth? So I think this is early days. The idea that the people have no choice and so forth is premature, in my respectful opinion. This is day number 3 or so. There are all these other days to go. And a number of other groups have been set up for one reason or another related to the Constitution amendments. And that is as it should be. I think that in the final analysis, the best amendment to a constitution is one, especially if it's a major reform, it's one that has something for everyone. It is my humble opinion that when people sit down and comb through this constitutional reform bill gazetted this week, they will find that actually it has something for everyone. They will find that the next selection of the president will not be the business of UMP alone with their massive votes. Their massive votes will produce MPs who need to engage with other MPs from Binga and from Mzarabane and from Onde Valley to elect a president, but not as free agents. The Constitution says that the political system we should endeavor to create as a foundational value of our country is a multi-party democracy. With the hybrid changes that have been done in Zimbabwe, it is no longer possible to have a parliament whose composition will be just one party. The electoral system forces and to assure that there will be some other party or parties. And that's a good thing. These sort of things, yes, would be nice if we can do them overnight. But by their very nature, they take time. But in order for them to happen, like they say, a journey of 1,000 miles starts with the first step. We should start that first step from a foundational point of view, from an institutional point of view, from a an institutional point of view. It is my considered judgment that this is a good start in that regard. It would be unfortunate if by the end of the day, something happens and as a country, we do what we did in 2000, throw away the baby with the bathwater. It is better to be constructive, suggest amendments to the amendments, engage, and let's not turn the engagement into shouting matches, accusations, and counter accusations of a personal nature. It's not my intention to engage anyone shouting and exchanging epithets. My intention, my prayer, and my hope is that we engage each other with mutual respect as compatriots who, for a number of reasons, including God's creation and the reality of human life, we have different experiences, different values, but we have to deal with each other. We have to meet somewhere because we have one and the same country, and no one is a monopoly to that country. And if we can discuss those problems, agree where we can and disagree where we do, but have mutual respect, for me, that would be better. I regret that there was some shouting in this stuff, and quite frankly, this is the first time I engage justice through talking, but I followed his work. I read most of the things he writes. I admire him as an up-and-coming intellectual who is multidisciplinary. I'm surprised that he wants to beat the drum about lawyers, when he himself is a good example of a grounded lawyer with a broad perspective. And in some of the things he writes, he comes across as a political scientist, a sociologist, and so forth. And that is a very good thing to see. And it reminds me of our own experiences in the early 90s, late 80s at the University of Zimbabwe. Our body politic needs young and sharp minds like Justice. But I think if there's anything to learn from some of us who are now getting close to the other side of midnight, it is that the best engagement is not the one that destroys. It is the one that builds. And that it is not necessary, as the experience of academics in other jurisdictions has shown, to always engage by demolishing, by casting aspersions. You will make people who should actually be your supporters and your audience stay away and lose out, but you also lose out if you are not able to influence. I believe, and I say that with respect, the best that academics can do is to advise the government of the day constructively and give them the ideas. And if they don't take the ideas, it's not a problem. It is not a sin. There is no government anywhere in the world which doesn't benefit from academic analysis and advice. And it's not good to vitiate that opportunity or possibility by shouting epithets from the terraces and make people misunderstand you, especially when one is such a bright mind, as undoubtedly, and to use the word of the judgment, unquestionably. Justice is a good mind. He's a good guy. You can tell that he is a scholar here, But to be a scholar like Aristotle, like Plato especially, who comes up with the Republic as a radical statement of the kind of constitution society might have, and then as he grows up, realizes that no, that Republic it doesn't work in reality, and comes up with the laws. And the laws is a conservative but relatable paradigm when it comes to the construction of the state. So thank you, not only for inviting me, thank you, Justice, for engaging me. I hope we will engage. I hope we will improve our nature and content of engagement. But sometimes it's very hot in the kitchen, and those who can't stand the heat should stay away from the kitchen. I thank you.
Well, thank you so much, Prof, for coming through. And we always reach out, and you've never turned us down. Thank you so much for that. And now I'll give Dr. Justice a chance to also give his closing remarks. Over to you, Dr. Justice.
Thanks, Nonhlanhla. I will make my closing remarks very briefly. One is that what we are facing in Zimbabwe is a planned constitutional coup, precisely because I've been accused for not explaining what this means before. Precisely because the constitution is being changed to subvert the presidential term limits without following due process. The second point I want to make in conclusion is we have been told countless times that this proposed bill does not seek to lengthen anything. This is not true, because clause 5 of that proposed bill seeks to lengthen the current term of President Mnangagwa, which is supposed to end in 2028 September, and the bill wants him to continue until 2030 without asking Zimbabweans for their approval. So it's simply not true that the bill does not seek to lengthen anything. Thirdly, and my final point on this is whatever so-called noble intentions behind this bill are, those intentions must be achieved through processes that uphold the Constitution and the rule of law. That means the government must go back to the people and seek their approval through at least 2 national referenda on two questions. One, whether the term of office for the president should be extended from 5 to 7 years, and whether those changes should benefit the incumbent president or not. And that's the constitutional position as reflected in Section 3287. That someone may have disagreements with me about that, it's their right. It doesn't make them a fool. It doesn't make them a charlatan. It doesn't make them any of the superlatives that we've had Professor Moyo articulating in the heat of the moment. It does, for me, it doesn't. And the toxicity that we need to deal with in our body politics is the toxicity that we have seen in this debate, where there are attempts to go after the person, even after the criticism has been directed at public positions that the person has declared. Nothing personal. These are public positions. If someone comes after my communications that I have made personally, then that's a problem. But if someone critiques what I have put out there, either in the form of books or in the form of social media posts, then it's fair game. Otherwise, thank you so much, Zenzile and Nonhlanhla, and have a wonderful week.
Well, thank you so much, Dr. Justice, for coming through and for honoring up to this debate. I mean, we've had numerous conversations in terms of the Constitution and the amendments as well, and you've always come through. So thank you once again, Professor Moyo. Thank you so much, Dr. Mavedzenge, for your time and your insights. Today's conversation reminds us that a constitution is more than just paper. It is a national promise, and it is the only thing that stands between the will of the people and the whims of power. Zimbabwe's future isn't just about who leads, but about whether the rules apply to everyone equally. Please, if you haven't followed SiteZW, make sure that you follow us here on X for more of these essential conversations. I am Nonhlanhla Mapiwa. Let's keep the conversation going in replies, in responses. I know Prof and Dr. Mavedzenge will also continue this conversation offline. Otherwise, it's been a lovely morning. We are now into the afternoon. Some are now going to bed. Have a good night. Some are just waking up. Good morning. And, otherwise, have a lovely, lovely day.